I'm for the petitioner, and Lordship has directed by order dated 2610 to assist this honorable court regarding whether petition filed before the Supreme Court is covering the prayers in the PL which I filed. Lordship, in this regard, I'm pressing for prayer number D and E, which is in page number 53 of the main petition, Your Lordship.
D and E.
Lordship, may kindly allow me to read prayer number D and E. Lordship, prayer number D is that is honorable court may be graciously pleased to issue directions or orders to respondents to make already procured blood component separator at NHAK operational. And prayer number E is to issue orders and directions to respondents to set up blood component separators in Eastern Nagaland to bridge plethora of infrastructural gaps. Lordship, the prayers which is before the Honorable Apex Court is in page number 92, starts from page number 92. And although the other prayers in my main petition has been covered in this matter, Lordship, prayer number D and E has not been covered, Lordship.
Yes, sir.
Lordship, as far as the prayer D is concerned, Lordship, it's with regard to seeking a direction to orders and direction to a respondent to make the already procured blood components separated at NHAK operational, Lordship. The machine is already there, Lordship. The technicians have reached, but since the lab is under construction, Lordship, it will be functional very soon, Lordship.
Very soon means when?
Lordship, as soon as the lab is completed, Lordship.
And how about E?
E, Lordship, as per the affidavit filed before the Apex Court, Lordship, two districts, one district has been earmarked, Lordship. Two districts, Lordship, Kohima and Dimapur.
No, this is with regard to
Eastern
Nagaland.
Eastern Nagaland, Lordship. As far as Eastern Nagaland is concerned, Lordship, we have to give in phase-wise our requirement, Lordship. So as of now, we have asked for Kohima and Dimapur. That the two has already come, Lordship. And we'll be putting up our proposal to the Government of India, Lordship.
There's a specific prayer
Lordship.
for setting up in the Eastern Nagaland.
Lordship.
Have you filed an affidavit indicating what steps you're taken?
No, Lordship. We are yet to file, Lordship.
You file your affidavit to that effect?
Lordship.
And also with the
Prayer number D.
operational of the
Yes, Lordship.
district.
Lordship. Lordship, if some time may be granted, Lordship, then I'll be filing my affidavit, Lordship. Because as far as
When was this?
Mr.
PIL
Godrej?
filed?
Lordships,
2021.
When did you initiate the
Lordship, in the
work at Kohima?
Lordship, in the affidavit that I have already placed before Lordship, before the on component separation unit and 6 district level blood bank in district of Mokchung, Tingsang, Wokha, Mon, Zunyapoto, Pek. However, the blood bank in Tingsang, Wokha, Mon, Zunyapoto, Pek district are yet to be licensed. Because, Lordship, there are certain procedure usage. There has to be a consumption, Lordship. Having a blood bank, Lordship, just for the namesake, will not serve the purpose. There has to be usage. That is Apex Court, Lordship. We have made a categorical statement.
When are you completing the building?
Lordship, that I have already confirmed from this morning, Lordship, they have not given me the timeline. But if Lordship may give me some time, I can file an affidavit to that effect, Lordship. I can file an affidavit, Lordship.
Let me find.
Lordship, sir.
But Mr. Yoke Arka Achumi,
Yes, Your Lordship.
learned counsel for the petition. Mr. N. Muzil, learned counsel for respondents 1 to 5, 4,
Wonderful, Lordship.
shall file an affidavit
Lordship.
as to when the construction of the building for the blood bank in NHAK
Lordship.
shall be operational. Further, indication should be made in the said affidavits for setting up of blood component separator in Eastern Nagaland.
Lordships.
Let such affidavit be filed within a period of 2 weeks
Lordships.
from today.
Lordships.
List after window vacation.
Oblige, Lordships.
Oblige, Your Lordship.
For admission, item number 2.
May I please, Your Lordship?
Yes,
Lordship, my name has been wrongly shown as a counsel for the respondent in this case. Initially, I was the counsel for respondent number 5, but on the last occasion, it was the case against the respondent number 5 was disposed as not pressed. So, my lord, my name may kindly be deleted from the list.
yes.
Please, Your Lordship. Lordship, I have received the affidavit in opposition filed by respondent number 6 just a while ago, Your Lordship. So I may be allowed some time to file my reply, Your Lordship.
MS is still and counsel for the petitioner is allowed to file 1 week time,
Reply, Your Lordship.
1 week time to file reply to the counter filed by the respondent number 6. Stop. Registry is also directed to delete the name of Mr. Takamasal and the senior counsel for the respondent number 5 in the cost list after window vacation.
Lordship, interim may be continued. Your Lordship.
Interim order proceeding to continue till the next adjournment date.
Much obliged.
Not there. 26. Election Commission. So it is
Which petition is accordingly dismissed on withdrawal with liberty expected.
my lord, much obliged.
My Lord, item 12,
Yes.
going by the last president's lordship, this is pertaining to a school education department.
Okay. So let's discuss before any other bench without me. Put my name.
Obliged.
May I please your lordship? Lordship, item number 23. Last Thursday, this matter was kept part heard. However, my lord, the registry did not indicate that it is part heard. So my respectful prayer to upgrade it as part heard.
Call up to the motion matters.
Mr. Lordship. Lordship, item number 4, 6 and 7, Lordship, this pertains to school education department, Lordship.
Okay. Let's discuss before any other bench without me.
Obliged, Your Lordship.
May I please, Your Lordship?
It will be called up after motion.
May I please, Your Lordship?
Yes.
My Lord, I'm mentioning on behalf of K. Angami. My Lord, I beg to mention item number 30. Kindly list the matter on 15/12/2022, Thursday.
My lord, in that case, let it be after the vacation, my lord.
On request made on behalf of Mr. K. Angami, the government. List the matter after window vacation.
Lordship,
On top, you just put heard Mr.
Lordship,
Council.
item number,
30.
this also pertains to school education department, Lordship.
Okay. Please discuss before any other bench.
Obliged, Your Lordship.
My Lord, I beg to mention item number 6 and 7 on behalf of K. Angami.
That we have already passed orders.
Much.
May I please, Your Lordship? My lord, I beg to mention item number 9. On behalf of Subhamwati Walling, if this matter can come up after vacation.
On request made on behalf of Mr. Subhamwati, then the council for petition. List after window.
Obliged, my lord.
May I please, Your Lordship? I'm mentioning on behalf of AIME, Your Lordship. Item number 20, 27, and 28. She's yet to receive instructions.
Who?
AIME, Your Lordship. Item,
Yes, 20, Cindy Anga.
Yes, my lord, I'm for the petitioner in item number 20.
Yeah, Vitsule.
Lordship?
Yeah, Viteri.
Yes, lordship.
Her term is Viteri, and a council for petition. On request made on behalf of Mr. AIME, then the government advocate. 3 weeks' time is allowed to file contract affidavit. List after the window petition.
much obliged. Your Lordship, item number 27 and 28 also.
Yes, no one, okay. On request made on behalf of MSKIME, then government
AIME.
advocate. 3 weeks' time is allowed to file contract. List after window petition.
Much obliged.
Obliged, my lord.
Same order in item 28. Yes, please.
Yes, Lordship, I beg to mention item number 15 for R5 and 6. Lordship, I pray the matter be listed after the vacation.
Yes.
Lordship, I have no objection.
Yeah, mister?
Lordship, I'm appearing on behalf of my senior in Langkumar.
Okay. On request made by Mr. Yasantilong,
Lordship,
then the council for respondent 5 and 6 list the matter after interpretation.
much obliged.
Much obliged.
May I please, Lordship? Lordship, I beg to mention item number 29. My affidavit is ready and waiting for signature. Lordship, kindly list this matter after vacation.
Okay, on request made by Ms. So then the council governor advocate list after interpretation.
Much obliged.
Yeah, please, Lordship. Lordship, I'd like to mention item number 19, Lordship. Here, Lordship, the state is yet to file counter, Lordship. So, Lordship, may please list the matter after vacation.
Yes, Joshua?
Lordship, this is to do with the pay scale. Lordship, the petitioners are paid the 1993 ROP.
Then we require an affidavit from the state.
My lord, Lordship.
Heard Joshua Shekil and the council for petition. On request made by Mr. Zimomi, then governor advocate. 3 weeks time is allowed to file counter. List after window vacation.
My lord, the state should also make an effort that affidavit is filed right after the vacation, lordship.
That's what I've said.
My lord. Oblige your lordship.
Lordship, I beg to mention item number 11, Lordship, on behalf of MS Livica, Lordship, for the state respondent. Lordship, kindly list the matter after vacation, Lordship.
On request made on the MSG vehicle and the governor advocate list after window vacation.
Lordship, I have similar prayer for item number 14, Lordship.
Same order.
May I please, Your Lordship? My lord, I beg to mention item number 25. My lord, here I'm yet to receive instruction. So kindly list the matter after 3 weeks, my lord.
Yes, more.
I'm for the petition in this case, Lord.
Heard more Jamil than the counsel for petition on request made by E.T. Papon, then the government advocate. List after window vacation to enable him to file counter affidavit.
Much obliged.
Please, Your Lordship. I beg to mention item number 8, Lordship.
Yes.
Lordship, let it be possible for the day, Lordship.
My lord, from tomorrow I won't be available, so let the matter be come up after winter vacation, my lord.
You are appearing for? Yes, Imti. Heard Imti Longcha, London Council for Petition. On request made by CD Rongsang.
Yes, Lordship.
London Council for Respond number 8. List after window.
My lord, let it be fixed.
List on
Lordship, then on the 30th January.
30 January.
Much
obliged.
May I please, Lordship? My lord, I beg to mention item number 13.
Mm.
My lord, here I'm yet to file affidavit in reply to the affidavit filed by the respondent number 1 and 2. I may be allowed a week's time.
1 week time is allowed to Mr. Takakichi, London Council for the petition, to file reply affidavit to the counter filed by the state respondents.
Obliged.
List after 1 week.
May I please, my lord? I beg to mention item number 17 and 18, Your Lordship, on behalf of the counsel for the petitioner. My lord, kindly list these matters after vacation, Your Lordship.
On request made on behalf of London Council for petitioner, list after window vacation, same order, I do it.
My lord, I also beg to mention item number 16.
Yes.
Your Lordship, the state respondents have already filed their counter affidavit, so I may be allowed 2 weeks' time to file my reply, Your Lordship.
2 weeks time is allowed to MS.
Viteri.
Viteri, London Council for the petitioner, to file reply affidavit to the counter filed by the state.
Obliged, my lord.
List after window vacation. Yes, call up.
For motion, item number 1.
May I please, Your Lordship? As direction given by this honorable court, I have informed the department to furnish the information, but due to time constraint, they cannot provide the instruction. Let the matter come up on 15 Thursday.
If you don't get instruction, I'm disposing it off on the next day. Heard MS Eastern London Council for petitioner on request made by Mr. E.T. from the government advocate. List the matter again on 15th December.
Much obliged.
For motion, item number 2.
Yes, Your Lordship. The petitioner is approaching his honorable court. Yes, he's aggrieved by the order dated 3/6/21, which is on page 20.
Yes.
My lord, without giving him a due opportunity in the hearing, the DC Dimapur have quashed and cancelled his final mutation and pata number based on the order dated 3/5/2021.
3/6/2021.
Yes, 3/6 is based on the order of 3/5/2021, which is on page 2022. And my lord, the petitioner is praying for a fresh hearing in the before the respond number 3 and 4.
Why are you coming so late? More than a year after this order is passed. Maybe by now the respondents have taken steps.
Yes, the petitioner is looking after his ailing mother, and he's not in a
That
condition.
is not an excuse. Your right over your land, your title over your land is under a cloud.
Yes, my lord.
And you keep on sleeping for 1 year. What explanation has you given with regard to the delay in filing this petition? Have you made any statements? Why are you approaching this court so late?
No, my lord, I've not annexed any
Then-
statement. No. Was not in a condition.
Yes.
I'm here to receive the service copy, Lordship.
You've not furnished him a copy yet.
Yes, my lord.
How did the
Extra copy I'll serve
registry-
in the course of the day.
How did the registry accept this swift petition?
My lord, I have served him one copy, and the remaining will be served in the course of the day, my lord.
You've received a copy or not?
No, Lordship. The petition is not with me, Lordship.
My lord, the initial is given in the petition. On the
Where's the notice?
on page 1, on the back of the page 1.
Yes, you've received.
Lordship.
What do you have to say on this?
Lordship, at this stage, notice may be issued, Lordship. In the meantime,
I'm talking about the delay, not about the issuing of notice.
Lordship. Lordship, in that view of the matter, Lordship, let it come tomorrow, Lordship, so that I will have it. Since right now, I don't have the proof.
Hurt, Mr. You're good then?
Apa tu sepakai duit kamu? And my lord, in the cost list, the petitioner surname is written as Ate. It should be Aye.
Registry is directed to correct the name of the petitioner in the cost title, in the cost list. Stop. Heard Mr. So-and-so for the petitioner. On request made by V. Zimomil and Government Advocate, list the matter again on 13th.
For motion, item number 3.
Compensation matter.
May I please, Your Lordship? This writ petition is relating to the compensation. Compensation.
Yes, state.
Lordship, I'll accept notice for
Heard
responding.
Mr. M. Mero. Your good name?
Emiro.
You are the counsel for petitioner. Issue notice. Mr. Yangawati, the CGC intercepts and accepts notice on behalf of respondents.
One.
About 2? No.
They have their own.
About respond number 1. Stop. Mr. V. Zimomil and Government Advocate intercepts on behalf of respondents. 3 to 11. Petitioner to take steps for service of notice on respond number 2 by registered post AD within 1 week from today. List the matter after 4 weeks.
For motion, item number 4.
That please, Your Lordships. My Lord, in fact, this is the third or fourth round of litigation for the petitioners. My Lord, the petitioners are the first batch of BDO and other, my Lord, cadre officers who entered into service in terms of rule of 2006 through NPSC. My Lord, the private respondents where we don't know what has been revealed from record of the previous litigations, my Lord. They occupied posts which are not feeder posts. But they were brought on deputation and finally regularized. Now, my Lord, rule speaks of 25% through promotion from a particular feeder cadre, and none of the respondents are or were holding those feeder cadres. And 75% through direct recruitment through NPSC, my Lord. My Lord, we are the direct recruits. My Lord, we first challenged before this Honorable Court in 2018 seniority list, tentative seniority list published. My Lord, our challenge was set at naught on the ground, my Lord, that we did not challenge the original appointment and subsequent regularization orders of these people. My Lord, we carried it to division bench. Division bench was pleased to, my Lord, hold concurrently. My Lord, the sole ground is you did not specifically challenge the appointments of the private respondents. Having not challenged that, you cannot now come up and challenge the seniority list. If the substantive position in the cadre is maintained, how do you challenge the seniority list? My Lord, now we have filed 2 writ petitions. We held, my Lord, 248 of 2022.
Page?
No, my Lord, this is not a part of this record. It is pending before Your Lordship. Only a notice has been issued where, my Lord, we challenge the appointments and regularization of the private respondents. My Lord, subsequently, we also challenged the tentative seniority list by WPC 249 of 2022. Now, my Lord, when this matter is pending, the government has now come up with the final seniority list at page 134. That is under challenge before Your Lordship. My Lord, my only, my Lord, prayer is, the Lordships may decide the matter obviously after hearing them. We have challenged their substantive induction into the cadre also. So I've got it right. But my Lord, prima facie, Your Lordships have also held, my Lord, that prima facie, these people, the facts show, are not born into the cadre in accordance with rule.
Your first writ petition was dismissed.
Dismissed.
Division bench dismissed your appeal.
My Lord.
Isn't it?
My Lord.
There you did not challenge the appointment and the regularization of the private.
I am obliged, my Lord. Only because, my Lord.
In the next writ petition which you filed.
Now it is specifically challenged.
Can you do that?
Yes, my Lord. In my humble submission, it is not a res judicata because nothing is decided between the parties. It is told that we are not deciding this fact. How can I decide without a specific challenge made by you as regards their appointment?
Practically, Mr. Day, that is the whole issue.
He did not challenge, my Lord, but that doesn't mean that the issue has been decided. That is my humble submission. Probably it will not probably, my Lord, I will humbly say it is not even within constructive res judicata because it has to be a issue raised and settled. It was not even raised, and on that plea, my Lord, my challenge to the seniority list went off. Your Lordships also did not hold that the seniority list is proper. Your Lordships held that prima facie, as of date, you have not changed their appointment.
Where is that order?
My Lord, the single bench order
Yes.
is at, my Lord, it starts at page 67, my Lord. Your Lordship may kindly come to, my Lord, actually the certified copy will start from page 55. Lordship may skip and kindly come to page 67 straightway, my Lord.
Yes.
Or, my Lord, page 60 also. Lordships had taken note, page 60, my Lord, Lordships had taken note of the position as to how these people were inducted in service. The factual narration itself shows it is nowhere near the rules. But, my Lord, having said so, please come to page 67 for a moment, my Lord. My Lord, paragraph 12. Lordship gets it, my Lord. what can be noticed is that the petitioners have not challenged the absorption and regularization of the private respondents against the post of video. Likewise, they also have not challenged the office memorandum by which they were regularized. Therefore, in the absence of any challenge to the same, the petitioners cannot be said to have any grievance on their seniority position. Further, the tentative seniority list of 2015 and 18 not being final interstate seniority list, it would be only premature to challenge the same. Lordship may kindly turn to page 69 for a moment, my lord. What has fallen from this honorable court? Paragraph 15. Coming to the present case, as already noticed above, the petitioners have not challenged the absorption and regularization of the private respondents, but have only paid for refixation of the seniority position above the private respondents in the tentative seniority list of 2018. My lord, having noted thus, your lordships, ultimately, my lord, at page 71, paragraph 19, we are pleased to dismiss the petition. Because, my lord, there was no challenge. There is no question of any decision from your lordship. The dispute was not resolved, my lord. Without a challenge to their induction in the service, which I say is illegal, but I have not challenged. I failed in that part, my lord. My lord, in my humble submission, the issue being not decided, it is not a res judicata in this court, my lord. My lord, on the same line, the Honorable Division Bench also told that there being no challenge, how can I decide it? You are challenging the seniority on the plea that they are not inducted properly. And even if inducted properly, they must be held to be inducted after you. But where is your challenge to their induction?
Division bench has gone into detail.
Yes. Yes, my lord. But my lord.
Thereafter dismiss your.
Yes, my lord. Lordship may kindly look at page 78 onwards.
Yes.
There is no decision to the effect of the, my lord, sanctity or otherwise of the induction of the private respondents. Page 78, bottom, my lord. Roman 9. The main grievance raised in the writ petition is that the Rural Development Service Rules 2006 regulates the recruitment and condition of service of the employees of the department. The rule does not provide for appointment of service or department either by absorption or by regulation of the service. The respondent number 4 to 17 being appointed beholds the rules cannot be placed above the writ petitioners in the seniority list respective of so who are absorbed and regularized in the service prior to the appointment of the writ petitioners. Kindly now come to page 80, my lord. What has fallen from your lordships? Page 80, paragraph, my lord, it should be Roman 14, X15. The learned single judge, after hearing the parties, had come to the finding that the petitioners have not challenged the office memorandum of the so-and-so, which prescribed procedure for regular absorption and deputation is, and provides that the seniority of service will be counted on the absorption. The learned single judge also held that the writ petitioners have not challenged the absorption and regularization of the respondent number 4 to 17. My lord, kindly come to page 90. Page 90 onwards, my lord, the ratio of the Honorable Division Bench. Paragraph 22. My lord, we have considered this aspect of the matter and we are of the view that without challenging the notification dated 21/12/2007, the order is so-and-so by which the respondents were absorbed and or regularized in service, the OM dated so-and-so, my lord, this OM is the tentative seniority list. Published tentative seniority list so-and-so, placing the respondents over the appellants cannot be challenged. My lord, that's how, my lord, at page 102, your lordships were pleased to, my lord, concur with the findings of the Honorable Single Judge. Para 42. There being no challenge, my lord, in view of the discussions made above, taking into consideration all attending facts and circumstances, we find no infirmity in the judgment. My lord, the crux of the matter, if I may repeat, my lord, is that you have come and challenged the seniority list, also challenging their position and also telling that they are not inducted in service properly. Where is your challenge?
Division bench held that you cannot challenge the tentative seniority list.
In the absence of a challenge to the, my lord, substantive appointment.
Now today, can you challenge the final seniority list?
Yes.
When you can't challenge the tentative.
My lord, the ground is not on merit. The ground is because you had not challenged their appointment. You are challenging that the tentative seniority list is bad, but Mr. Petitioner, you have never challenged their induction in service. Without the now that, my lord, induction of service is under challenge. Induction of service is under challenge. My lord,
That you failed to do in your first writ petition.
my lord, I failed to do. That does not debar me under any law to do it on a.
That
My lord, constructive res judicata, even not even res judicata, even constructive res judicata is limited to an issue raised and decided finally. My lord, the issue having been not raised, my lord, it is always open in the interest of justice
Yes, buddy.
to be challenged at any point. My lord, in fact, I
Yeah.
will
Yeah.
humbly say, my lord,
Lordship.
after Umadevi's case, my lord, with all the, my lord, with all capacity at my disposal. My lord, page 53, while entertaining the first writ petition, this honorable court was pleased to observe that the crux of the challenge was in fact the, my lord, induction of the private respondent service. But because, my lord, my lawyer did not press it the way it is provided under rule, my lord, my humble submission, a citizen will not be penalized. Your lordships have never done that. My lord, the crux, my lord, after Umadevi, in a private law forum, this is different. But in a public law forum of equity like Article 226, whenever, my lord, your lordship looks at an indecision or infirmity in the government action, my lord, your lordship's hands touches that. My lord, that Lalit Chandra case.
Mr. Day, I'm still not impressed.
My lord, your lordship will kindly give me a full hearing for this. I will impress upon your lordship. Because, my lord, once an illegality has come to the notice of your lordship, would your lordship in a, my lord, public law forum of 226 lay off your hands, my lord? Only because the lawyers did not place it the way it should have been placed in terms of law. That is the
state.
Lordship, here I have instruction to appear on behalf of respondent number 1, 2, and 3, your lordship.
Then you can appear for 4 also. Is the director.
Lordship.
Yes. My dear, for the private respondents, my other brother, Mr. Takamasa had appeared. I don't know. Oh, yes.
Also for the private respondents, in the other two cases, 248, 249, I am appearing for private, all the private
No, but do
respondents.
you have
except two.
instructions to appear
Yes,
in this
yes.
writ petition?
Yes, so I have received instructions. So, my lord, I'll be appearing for respondent number 5, 8 to 17.
5,
8 to 17.
How about 6 and 7?
My lord, I have no instruction for in the other two cases also,
6 and 7.
except for 6 and 7.
So NPSC is also a pro forma respondent, my lord. Respondent number 18.
No standing counsel.
No
for
standing
NPS.
counsel. We have to serve copies.
So, your lordship, let this matter be clubbed together with
Yes,
248
my
and
lord.
249.
248 and 249.
Lordship, if the petitioner is pressing on interim, I have objection on that. Otherwise, notice me.
My lord, without hearing the other side, your losses will not injure anyone's right. May I humbly submit one thing? Let this be the final round. If the respondents take up any action in terms of the impugned seniority list, that will be the subject of the outcome of this, my lord, present proceedings. That will do.
That is fine.
So that I again don't have to come up with, my lord, if they at all come up with a promotion order, which will be illegal on the face of it, but let it be subject matter of this writ petition.
But Mr. SSD, Leonard Senior Counsel, assisted by Mr. Muad Jamil, Leonard Counsel for Petition. Issue notice. Mr. TB Jamil, you'll be as
Yeah, just engage counsel for
Leonard Counsel, Leonard Engaged Counsel appears on behalf of the respondents 1, 2, 3, and 4. And Mr. Takamasa, Leonard Senior Counsel, assisted by Mr. Sintilo, enters appearance on behalf of respondent number 5, comma, 8 to
17.
17. Stop. Petitioner to take steps for service of notice on respondents 6, 7,
and 18.
And 18 by registered post 80 within 1 week. 1 week from
My lord.
Stop. Respondents are allowed to file counter affidavit. You furnish extra copies.
I will, my lord. By tomorrow, we will furnish all the extra copies.
List the matter after 4 weeks.
Along with?
along with WBC number, give me the numbers.
248 and 249 of 2022.
248 of 2022 and 249 of
2022.
Stop. Any further promotion of the private respondents shall be subject to the outcome of this petition.
Much obliged.
Deeply obliged.
For motion, item number 5.
Yes.
May I please, Your Lordship? Your Lordship, here the petitioner is seeking appointment on compassionate ground. You know, here the petitioner father was a regular employee in the respondent department under principal chief conservator of forest and head of forest guard, warden life sanctuary Dimapur division, were expert on 26 December 2018. You know, here the petitioner mother predeceased to his father, and within a short span of 3 years, the petitioners had lost both of his parents. You know, I have annexed the certificate of the petitioner mother's.
Anyway, that we have seen. Only question is, you are claiming your appointment to a particular post.
Yes, Your Lordship.
By way of compassionate appointment.
Yes,
Can you do that? Do you have any right to claim for a particular post under compassionate appointment scheme?
Lordship, I beg pardon.
Yes. You can consider the matter.
Your Lordship, notice may be issued, Your Lordship.
What's the point of keeping this case pending? Consider the application in terms of your OM, but not to the post that he is
Yes, Your
claiming as
Lordship.
such.
Yes, Your Lordship.
Strictly in terms of the OM circulated by the state government, you consider his case. He has made representations in 2019 and 2021.
Yes, Lordship.
He has not taken steps till now.
But for 21, there's no receipt as such, but.
Yes, but in 2019 he has already made. Where is your representation?
You know, my second representation is dated Annexure H, page 27.
Learned counsel, you have not paginated the writ petition also. There's no pagination in the present writ petition. Learned counsel shall cure the defect, list the matter again on 14th December.
Tomorrow, Your Lordship.
Yes, day after.
Pleasure.
For admission, item number 10.
Sorry for interruption. I thought the direction was about my matter first.
I beg your pardon. For admission, item number 23.
The first. Lordship, parties are ready for disposal. So may I pray that this matter may be taken up after part 1?
Oh, we are in part 2 now.
Oh,
After part 1.
all right, Lordship.
Your Lordship, my senior counsel is engaged in court number 3. So if the item can be, if you please to extend.
Okay, let us see what the other matters are all about.
Lordship.
Come back.
Item number 10.
Maybe before Lordship.
Yes.
My Lord, this, by this repetition,
Oh.
we have challenged, my Lord, the order, my Lord, for non-appointment of the petitioner, my Lord. In the year 2012, there was a recruitment rally, my Lord, for ORL threat, my Lord, for the state of Nagaland, my Lord. Accordingly, my Lord, the petitioner has applied, my Lord, and he has qualified all the stages of the examination, my Lord. Finally, my Lord, he was informed, my Lord, by order dated 22/7/16, my Lord. He was informed that he got law in merit. For that case, he could not be appointed. That was the prefix. Now, my Lord, they have filed an affidavit stating that the petitioner last candidate who was appointed, my Lord, scored 49 marks, whereas I, the petitioner, has scored only 44 marks, which means 5 marks lesser than the last candidate as projected by the respondent. That was the issue. Now the question which I raised, my Lord, the present petitioner.
Let us see the affidavit filed by the respondents.
Yes.
Saying that the last candidate was appointed.
Of last candidate scored 49 marks.
Yes, let us have a look at that.
Yes.
Yes, which affidavit is it?
My Lord, there are two affidavits. Let us see first, my Lord, the first affidavit in terms of order, my Lord, file of order dated 12/2/2021.
12?
First affidavit was filed on 12. In terms of order dated 2/12/21. It starts from page 3.
One minute.
The next
one
are
minute,
3.
1 minute. I'm not getting the check. Affidavit filed on?
It was, my Lord, it was not in my copy, it is not there, but it was filed in terms of order dated 2/12/2021, my Lord. First affidavit. Additional affidavit, my Lord. Just to make it easier, my Lord, I just make debulation, my Lord. Just have a look, my Lord. I just make a debulation.
No, this is okay. I want to see the affidavit.
Yes, yes. I extracted from the affidavit, my Lord. Just to make it convenient, my Lord.
Yes.
Lordship got it. If I may rely, my Lord, there, my Lord sees out of, my Lord, there is, I'm only relying on ST category, my Lord. There are two category. One is general. It carries 12 candidates, and so far ST is concerned, there are 13 candidates. Now, here,
It's only 12. 12 for ST, 13 for, yeah.
here, my Lord, it shows 55 candidates. First one to page 1 to 6, which I make.
You got 44 marks.
I got 44 marks. My name will be at serial number 8 in the first page, my Lord. Petitioner, read petitioner.
Yes.
I've got 44 marks.
Then
This was the combined, they have, my Lord, they have projected, my Lord. Now, next.
Which is the last candidate that was appointed?
My Lord, may kindly come to page 10, serial number 18. Serial number 18, my Lord. Page 10 of my tabulation, my lord. Last name was Koviyi Chizu. That was the last candidate. It score 49. Now my name at serial number 26, my lord. This marks, this tabulation I have made according to the marks as extracted from the affidavit. This ranking wise, this in this descending wise. So here, my lord, it shows that, my lord, may kindly page 9, serial number 1, Manju Hazarika. Lordship, this was a general category in my submission. Because the Manju Hazarika will never at any by any time, my lord, this will not have been projected, this would not have been projected or inserted in the ST category. Because these posts are specifically reserved for ST category. My lord, next, my lord, serial number 12 and 13. Dinesh Kumar, Sushil Kumar. The another motor candidate. These were included. Initially, my lord, 11 candidate. I'll just show you, my lord. Initial page, my lord. Page 2. Can you see? Initially, 11 candidate belongs to general category were included, my lord. So, Sultan Kumar, Paul, I make it Paul, sir, lordship. Then Torgao Limbu, next, my lord. Sushil Pasumatari, next, my lord. Then Chandra Pasumatari, my lord. Lordship court. Then page 3, lordship may kindly come. Pranab Chandra Puru. Next, actum lower part, my lord. Python Kifusa, belong from Timasa, my lord. Then, my lord, next page, page 4, Manju Hazarika. Then, my lord, next keep Dinesh Kumar, Sushil Kumar, Ropin Chwef Kifusa, Pohum Bosumatari. These are the candidates, my lord. Out of these 11 candidates were included in the ST. But this will be in contrary to the rules, my lord. Because this specifically reserved for ST. This should not have happened, my lord. Now, my lord, before that, my lord, I'll just...
Let us see the advertisement now.
I'll just show, my lord, the affidavit, my lord.
One minute. Let us come to your writ petition. Any advertisement made?
My lord?
Any advertisement?
My lord, also unfortunately, my lord, I could not annex, my lord, advertisement because initially I filed in RDI, my lord. Now they say that, my lord, we could not, since RTI is exempted, my lord, so far Assam Rifle part is concerned under section 24, schedule 2, my lord, and read with section 8J. They say that we could not provide you and you are the third party. They have informed to my learned counsel, my lord, advocate. So petitioner he says that since they have said that third party information we could not provide, petitioner himself also filed an RTI that has been denied. Otherwise, my lord, this court has held, my lord, it is not a third party information, my lord. When it comes to, my lord, selection marks obtained by the candidate in a public service, my lord, this will not be covered, my lord.
It is not denied that the recruitment was took place in October 2012.
Yes, yes.
Then?
Now, my lord,
where's the results? Result of the recruitment.
Result, my lord. That's what an additional affidavit, that will be the result, probably. Additional affidavit. What I have make a stipulation, my lord. That will probably the result. And the merit list.
2012.
Yes, my lord.
When was this published?
I don't know, Lordship. I don't know.
You have no idea. How can you have no idea when this was published?
But in presence of that advertisement, they have applied.
They have applied in pursuance to an advertisement. You are not denying the advertisement. You are not denying that the recruitment took place in 2012.
Yes.
Correct? Yes. So I want to know when these results were published. And have you issued any appointment orders?
Yes.
When?
I don't know, Rajib, when it was.
What is this?
Give me some time. I will.
See, the issue is this. This is a recruitment of 2012.
Yes.
You published the result. You don't know when you published the result. You've met appointment orders. You don't know when you met the appointment orders. There's a third party right already involved here. And the petitioners had not met them parties. That's why I'm asking you this question. You should be aware of that.
In fact, if the petitioner is IPF, they should have completed the.
That is why I'm asking you this question. When was the result published and when did you make your appointments? Where are the appointment orders?
Give it some time, Rajab, and I will furnish all the documents.
How many times you've been made to file affidavits? You filed 3 affidavits on the direction passed by this court. Still then you have not. At least this was your duty to know when the results were published, when the appointment orders were. These are the basics.
Rajab, the direction of the court was to publish to bring in record the result of the ST only ST. Not
That's
the other.
what you
So
should
on
know,
basis-
the
on
result
basis
of the ST.
On the basis of that, the result of the ST has been.
Let us know when this result was published. When we said to enclose the result of the STs, you should have made you should have come with the date on which this was published. When was this writ petition filed?
Yeah, my lord. Initially, my lord, I
2019.
Kate, my lord, and then ultimately, my lord.
Okay. Your good name, please?
My lord, N.K. Muri, my lord.
Heard Mr. N.K. Murel and the counsel for the petitioner. Stop. Learned CGC shall file an affidavit indicating the dates on which the results pursuant to the recruitment of this was to the post of
ORL, operator radio line.
When was the recruitment held?
My lord, it was in the year
Pursuant to the recruitment held in the month of May 2012.
October.
Stop. The said affidavit should also contain the date on which the date on which appointment were made to the said post. Stop. List this matter after 2 weeks.
Along with the advertisement also.
Along with a copy of the advertisement. Yes.
My lord, if I may allow to pray, my lord, let the entire record maybe.
Or
let-
you can produce
let,
the records
Let them
also.
produce, my lord. That will be convenient
Rajab,
for this court, my
It's a
lord.
very huge record.
Let that extract part maybe produce, my
Whatever
lord.
it is, let the CGC shall also produce the records by the next retrievable date.
For
List
further
after
adjudication, my lord.
winter vacation.
Lordship, it will take more time because during they have also vacations and the records are not here. It's in Jipura.
Where is it?
Agartala.
Akatala, you can get it. Winter vacation is a long time here.
For admission, item
My
number.
lord, that may be fixed, my lord.
Okay. 31st January.
I mobilize, my lord.
For admission, item number 21.
Lordship, if my lordship may kindly allow me, let this, the result sheet be with respect to the ST only.
No, all, because you've included some of the general candidates.
No, that is only
Let
the
us
allegation.
see, let us
It's
see.
only the allegations.
Yes,
Let
for,
us-
at least if record come, my lord, that will be
Let
fair,
us-
my lord. I'm obliged.
For admission, item number 21.
May it please your lordship. Lordship, the item number 19 was not called out.
That was adjourned.
19 was not adjourned, lordship.
It was adjourned.
Or 14 was adjourned, lordship.
19 also was adjourned by the State Council. You were not informed?
I was not informed, lordship. I
Call
was
the-
waiting for the
call
item.
the State Council.
My apologies, lordship. 19 was mentioned, but 14 was not mentioned, lordship.
14 was also mentioned, Joshua. Yes.
My apologies, lordship. I was not informed by the other party, so.
Okay, we'll see. Yes. Item 21.
21. For admission, item number 21.
My senior is coming, lordship. Yes.
Actually, your lordship, this is ready for hearing. I'm told it is part of matter.
No, part of matter is taking some time because the other council is in the other court.
Is it? Otherwise, your lordship, this is a very short matter. May I please, your lordship?
Yeah.
Your lordship, the petitioners, this is a joint petition. There are 7 petitioners, your lordship. They agree by the cancellation order of the offer of appointment by which they were appointed to the post of Constable, general duty in the CRPF. The impugned letter is at page 167. 167. Your lordship.
Yes.
May I read out? To such and such, Rovato Pozar, he is the petitioner number 1, your lordship. Subject regarding cancellation of offer of appointment for the post of Constable, general duty in CRPF. You were selected provisionally for the post of Constable GD in CRPF. Accordingly, you were issued offer of appointment by this office letter number such and such, dated such and such by this office, with direction to report in this group center, GC, on 16/3/2021. On reporting, you had submitted all testimonials in originals for documents verification and checking of your original documents, which were under process. In the meantime, case of district-wise mismatch cases were called for by our CRPF headquarters in consultation with Staff Selection Board. Accordingly, on checking of the record documents, it is found that your district of domicile, Kohima, which was mentioned in online application form, is not matching with your permanent residential certificate, PRC, in which your domicile district is pegged as submitted by you. And as per direction of our CRPF headquarters, advertisement published, notification issued for the subject post. In view of above, your case is forwarded to CRPF headquarters for clarification. Thereafter, as per decision received from CRPF headquarters, your case was forwarded further to staff selection headquarters for revision of result of candidates whose data found mismatch, and now the direction have been received to return all such candidates back to their home till receipt of final decision from SEC on the subject matter. That means final decision is yet to be taken, Your Worship. Number 2, in view of the above, you are directed to return back to your home till receipt of decision from CRPF headquarters in this regard. The offer of appointment issued to you by this office letter that is reference such is hereby cancelled. This is contradictory. By this letter, they are saying that final decision is yet to be received regarding cancellation of my offer of appointment. But then last sentence, you say that your offer of appointment is cancelled, Your Worship. Now, this is at page 167, annexure 14, A to G, Your Worship, is in series. These are all similar impugned order, same date, Your Worship, in respect of petitioner number 1 to 7, Your Worship. Now, how the petitioners were selected, just on the selection process. This is a very short matter, but just on that, I'll take just 15 minutes time, Your Worship. May I take Your Worship to page 62? This is the advertisement. Page 62, annexure 8. This is the notification issued by SSC. May I read out? This is published on dated 21/7/2018. Notice: Constable GD in Central Armed Police Forces, NIA and SSF, and Rifleman GD in Assam Rifle, examination 2018. Now, numbers such and such. The Staff Selection Commission will conduct an open examination for recruitment to the post of Constable General Duty in BSF, CISF, CRPF, Indo-Tibetan Border Police, Sastra Simabal, NIA, and Secretariat Security Force, and Rifleman General Duty in Assam Rifle, as per the recruitment scheme formulated by the Ministry of Home Affairs, as per the MOU signed between Ministry of Home Affairs and the SCC. The recruitment process will consist of computer-based examination, physical efficiency test, physical standard test, and medical examination. The salient feature of the recruitments are as under. 1. The examination will be advertised by SSC based on vacancies intimated by MHA. 2. Application will be accepted through online mode only from the candidate from all over the country. 3. Computer-based examination will be conducted by the Commission in English and Hindi only. 4. Physical efficiency test, physical standard test, detailed medical examination, review medical examination will be scheduled and conducted by the CAPF. 5. Collection of record eligibility certificate, documents from the candidate, and their verification will be carried out at the time of detailed medical examination by the CAPF. This is Central Armed Police Force. 6. Vacancy of Constable GD in NIA and SSF will be filled on all India basis, whereas vacancy in all other CAPF will be filled as per the vacancies available in various states, union territories. In addition, in other words, vacancies are statewide, Your Lordship. In addition, vacancies are earmarked for the border guarding district and militancy Naxal affected district, which are reserved for the candidate of this district only. 7. The list containing name of border guarding district and militancy Naxal affected district are available at annexure 12 and 13. I'll be coming to this in the course of my submission, Your Lordship. 8. Final result along with force allocation will be declared by the Commission based on such and such. Now 8, 9, Your Lordship, let me just skip 10 also. Now para 2. Vacancies and reservation are as follows. There's a table shown in the third, Your Lordship. CRPF is given, Lordship has got it. CRPF. So male ST, the total number of vacancies, this is state-wise. And the last para, note 3, Lordship. Note 3, Your Lordship may see. As the vacancies have been allotted to the concerned state union territories, candidates are required to submit domicile permanent residence certificate of the state UTs indicated them in the online application form at the time of DME. This is detailed medical examination, documents verification, failing which his or her candidature will be cancelled forthwith, and the candidate will not be allowed to appear in the detailed medical examination, DME. If a candidate produces domicile permanent residence certificate PRC issued by a state other than the state mentioned in his or her application, he or she will not be allowed to change the state at the time of documents verification, and his or her candidature shall be cancelled straight away. Now, may I take your lordship to 3, para 3, page 64. There is nationality, citizenship. Candidates must be a citizen of India. Vacancies are state union territory wise. Hence, a candidate must submit domicile PRC against his or state union territories. Now, may I take your lordship to page 68, para 8. That is the center of examination. Lordship has got it. Page 68, para 8.
Yes.
Center of examination. Relevant page will be 69. At column 5, third line, Kohima is there. Kohima is one of the center for examination. Now, next page, page 70, para 70. Para 9, page 70. There is scheme of examination.
Yes.
Now, a scheme of examination, number 1 is this will be computer CBE, computer based examination, page 71. So, computer based examination will consist of general intelligence and reasoning, general knowledge and general awareness, elementary mathematics, Hindi, English language. Now, page 72, Roman 2 is the physical PET, physical efficiency test. And last column table is there, physical standard test. Physical efficiency test will comprise of your lordship running, those things, weightlifting, and physical standard will be height, chest, those things. Now, next page, lordship may kindly turn to page 24. Column 4, that will be the medical examination. Lordship has got it. Now, may I take your lordship to page 80? That will be the mode of selection. Page 80. Page 80, mode of selection. Lordship has got it. So, mode of selection will consist of computer CBE, physical efficiency test, physical standard test, and medical examination. Now, page 81.
Yes.
Roman 11. This will be relevant, your lordship. Candidate will be considered for the vacancies of the state union territories and further for the vacancies of border guarding district, militancy, Naxal affected district based on the information provided by them in the online application form and subsequent submission of relevant domicile certificate at the time of DME documents verification. Candidates, these are bold, candidates are advised to be very careful and should exercise due diligence while providing information about domicile state and district in the online application form. No request for change of domicile state and district will be entertained by the Commission after submission of application form under any circumstances. If there is any variation of district and or state mentioned in by the candidate in the online application form and the domicile certificate submitted by them at the time of detailed medical examination, documents verification, their candidatures will be cancelled forthwith and they will not be allowed to participate your lordship, in the detailed DME. They will not be allowed. Now, may I take your lordship to the note? Lordship has got it? Just second paragraph from the bottom. The candidate applying for examination should ensure that they fulfill all the eligibility condition for admission to the examination. Their admission at all the stages of examination will be purely provisional, subject to their satisfying the prescribed eligibility conditions. If on verification at any time before or after the computer-based examination, PET, PST, and medical examination, as well as after issue of offer appointment, joining the force organization, it is found that they do not fulfill the eligibility condition. Your Lordship may kindly mark this eligibility condition. Their candidature selection for the post will be cancelled by the commission CF. Means only commission will cancel, not any other authority. But Your Lordship, para 11 top and the note should be read separately. Para 11 relates to the domicile certificate, PRC, whatever, which will be verified at the time of DME. Now, regarding cancellation, is note relates to eligibility condition. So, my submission will be, Your Lordship, though there's mismatch in the district, domicile district and PRC, it has nothing to do with the eligibility condition, Your Lordship. Now, next page 83, Your Lordship. Just this is the last part of the advertisement. Page 83, para 15. Lordship has got it. Para 15, course jurisdiction. I'm referring to this because to satisfy Your Lordship, this court has jurisdiction. Any dispute in regard to this recruitment will be subject to court tribunal having jurisdiction over the place of concern regional, sub-regional office of the commission where the candidates have appeared for the CBE, computer-based examination, Your Lordship. Now, Kohima Center is there, Your Lordship. Kohima is the only center in the state. Now, may I take Your Lordship to page, this thing, for CBE, page 114. This is my center for CBE, computer-based examination. 114.
Yes.
This is petitioner number 1. Address I've given. Examination venue. Lordship has got it. In bold it is given. Ion digital zone, such and such, LKL, Tinpati Junction. So my computer exam center was at Kohima exam center. So this court has jurisdiction, Your Lordship. Now, may I take Your Lordship back to page 62 because I would like to rely on 3 sub-para of para 1. Because I've said that annexure I'll be referring to, Your Lordship. Now, 5, let me read out again. Collection of record eligibility certificate documents from the candidate and their verification will be carried out at the time of DME by the CF. Regarding domicile certificate, whatever, that will be at the time of detailed medical examination. That I have already crossed. I've been even given offer of appointment. 6, vacancies of Constable GD in NIA, such and such, will be filled up all India basis, whereas vacancy in all other CF will be filled as per the vacancies available in various states. In addition, vacancies are earmarked for the border guarding district and militancy Naxal affected district, which are reserved for the candidate of this district only. Now, which are the district? 7. The list containing border guarding district and militancy Naxal affected district are available at nature. 12 and 13, Roman 12 and 13. May I take Your Lordship to page 99? Lordship has got it. Page 99. Relevant will be page 100. 100, Nagaland is there. Peg. Peg is one of the border guarding district, and here 3 of the petitioners are from Peg district. I'll be coming to that. Now, next page is 103, that is annexure 13. Annexure 13, it gives a list of militancy Naxal affected district. Second last column, Nagaland is there, Your Lordship. Now, all district. In the state of Nagaland, all districts are classified as militancy affected district. Your Lordship. Now, in response to this notification, this notice advertisement, Your Lordship, the petitioners, they have submitted their application. Application will start from page 107.
Yes.
107. Lordship has got it. Now, in the table, Your Lordship may kindly see serial number 16. State, UT of domicile. Lordship has got it. 17, district of domicile, Kohima is given. And Your Lordship may also turn to next page, postal address. Postal address. It relates to, in respect of petitioner number 1, he has given Kohima. Postal address also, he has given Kohima. Lordship has got it.
Yes.
Now, accordingly, the petitioners were issued admission certificate, which starts from page 114. This I have taken, Your Lordship, to show the exam center. So this admit card relates to CBE, computer-based examination. All the petitioners were issued similar or e-card. Now, e-card for PET, physical standard, is at page 122. Physical standard test, physical. Lordship has got it. Now, other petition also similar card were issued. Now, for DME, the e-card is at page 129, detailed medical examination.
Yes.
Now, Your Lordship, having successfully qualified in all the 3 tests, Your Lordship, the petitioner were finally issued the offer of appointment, which is at page 136. Lordship has got it. 136. This is the offer of appointment. Same date for all the petitioners, Your Lordship. Now, these are in series, Your Lordship. Now, and they were also assigned the force number. In the offer of appointment, the force number is not there, but may I take Your Lordship to page 174. 174, this is a representation submitted by the petitioner, one of the petitioner, where 174.
Yes.
Lordship has got it. Now, subject is there, reference. Lordship has got it. Now, they have given, petitioner has given roll number and force number. So even force number was assigned, Your Lordship. Now, while discharging their duties, Your Lordship, the petitioner were served with the impugned letter, which I've taken, Your Lordship, cancelling the offer of appointment, Your Lordship. Now, as reflected in the cancellation, the impugned letter, Your Lordship, the offer of appointment was cancelled on the ground that there is mismatch of district. That means the district of domicile and the district from where the petitioners had obtained the PRC. Now, Your Lordship may also appreciate the fact that supposing I am here in Kohima, but I have to obtain my PRC from Mokshu. Lordship. So that was the mismatch, Your Lordship. Now, for example, may I take Your Lordship to page 25? Page 25, which I've already taken you. I have taken Your Lordship to that, but again, for Your Lordship's satisfaction, this I have not taken, page 25. This is the PRC of petitioner number 1. Lordship has got it. He has obtained the PRC from PIG, Your Lordship, though he was residing at Kohima. Now, may I take Your Lordship to page 107? 107, I have already taken Your Lordship to that. but just in the application form, to be more clear, Your Lordship. At serial number 17, district of domicile, he has given Kohima, though he has obtained the PRC from PEG, Your Lordship. Now, similarly, just to cut short, Your Lordship, may I take Your Lordship to page 168. In 168, this is petitioner number 2. This is the impugned cancellation order of all of it. 168, Your Lordship. 7th line, in the middle, in bold it is given. District of domicile is given Kohima and postal address, but PRC, he got it from Oka. Now, next, similar petition number 3, Kohima Mokyong. So these are the mismatch, Your Lordship. Petitioner number 4, 170, Dimapur Mokyong. He obtained the PRC from Mokyong, but then the domicile district he has given Dimapur. Similarly, page 171, petition number 5, Dimapur Phek. 172, Kohima Phek. Right. Petition number 7, Dimapur, Oka, though he has obtained the PRC from Oka, like he has given his address as Dimapur, domicile district. Now, Your Lordship, instead of mentioning the native village, as mentioned in the PRC, to which the petitioner originally belonged, Your Lordship, as the domicile district, the petitioners have mentioned the district where they're presently staying. That is the thing, the mismatch, Your Lordship. Now, my submission, Your Lordship, is that as per the advertisement notice, Your Lordship, the vacancies are state-wise. And then the domicile district is relevant only to identify as to whether the candidate is from militancy affected district. And secondly, whether the candidate is from border guarding district, Your Lordship. Otherwise, there is no dispute that they are indigenous inhabitants of the state of Nagaland. But why domicile district is necessary? Just to see whether the candidates, they are entitled to the additional vacancies which are reserved for the militancy affected district or for the border guarding district. In this case, Your Lordship, 3 of the petitioners, they belong to PEG, but they have not given PEG. Had they given PEG, they would have got an added advantage because there's additional vacancies for border guarding district, Your Lordship. Now, as all districts in the state of Nagaland, Your Lordship, are declared as militancy affected district, by not mentioning the district to which the petitioner originally belonged, Your Lordship, no, the petitioner has not gained any undue advantage or personal gain, Your Lordship. The mistake was bona fide. Since they were staying, they have just given the postal address, domicile district, the place where they're staying, though they have obtained the PRC from the native district, Your Lordship, respective district. Now, as regards this examination verification as to whether there is mismatch in the district, Your Lordship, now I have taken Your Lordship to page 81. Those are to be verified at the time of detailed medical examination, Your Lordship. Page 81. Page 81, I have taken Your Lordship to that, Your Lordship. At the time of detailed medical examination, because, may I take Your Lordship to page 81, the last sentence. In case if there is mismatch, Your Lordship, their candidature will be cancelled forthwith and they will not be allowed to participate in the detailed medical examination. And all the documents were verified at the time of detailed medical examination. And the respondent, they're also aware of the fact that the petitioners, they belong to the state of Nagaland, and all districts in the state of Nagaland are classified as militancy affected district. So that is why the petitioners, they were allowed their candidature was not cancelled, but they were allowed to participate in the detailed medical examination, Your Lordship. Now, therefore, Your Lordship, and when this thing, I'm challenging this, saying that, and that the order, impugned order has been issued by the respondent number 5, DIG, Your Lordship, Group Center. Now, on extraneous consideration, not in terms of the notification or advertisement which has been issued by the Staff Selection Commission, Your Lordship. And as I've said, Your Lordship, respondent number 5, he is not the competent authority. If at all it is to be cancelled, it can be cancelled only by the commission. That is what the notification says, Your Lordship. And even the impugned letter speaks for itself till final decision is taken. So when the commission is yet to take final decision, Your Lordship, how can my offer of appointment can be cancelled, Your Lordship?
So far cancellation is concerned, it is the commission oblique CAPF.
Lordship.
It's commission oblique CAPF.
CAPF. But it is not by CAPF. And then I'll be coming to the affidavit. In the affidavit, they have mentioned only commission. Okay. The final decision. I'll be coming to that, Your Lordship. So therefore, Your Lordship.
Is there any indication that the SSA has taken a final decision?
No, I'm coming to that. I have submitted representation, Your Lordship. But then representation has not been considered, not been disposed of. That is why the petitioners were compelled to approach this honorable court by way of filing this petition, Your Lordship. Now, I will come to that affidavit. Affidavit has been filed by the president. In the affidavit, Your Lordship, the respondent have not denied the fact that the vacancies are state-wise. Nagaland has its own quota, and it is not a case of the respondent that the petitioner they don't belong to indigenous inhabitant of Nagaland, or that it is not a case of that the district to which the petitioner belongs, whatever, does not come under the militancy affected district. And it is also not the case of the respondent that they are not eligible. It is only the case of the petition of the respondent that there is mismatch in the district of domicile and the PRC, Your Lordship. Now, okay. But before I take Your Lordship, to the affidavit in opposition, just let me refer to my affidavit, my petition, and I'll be relying on the reply, their reply. My petition at page 12, para 13. May I read out? That clause 3 of the notice dated such and such, and it provides that vacancies are state-wise, and hence candidates are required to submit domicile PRC against his or her state duties. In the application form, the petitioners have mentioned the PRC and district of domicile as under, which I have shown. It is stated domicile district as entered in the online application form, as well as in the PRC falls within the state of Nagaland, and all the petitioners are indigenous inhabitants of the state of Nagaland. Now 14. That the petitioners had inadvertently mentioned the wrong domicile district in the online application form. It was bona fide mistake and not intentional, in as much as the petitioners had no intention of misleading the respondent, as they could not have gained any advantage by mentioning the wrong domicile district in the application form. Now, last paragraph, para 17, Your Lordship, just 3 paragraphs of your line. Next page, 14. That the note appended to clause 11 of the notice that such and such is reproduced below. Mode of selection. The candidates applying for the examination should ensure that they fulfill the eligibility criteria. This is where the commission has been given in case found ineligible. It may be mentioned here that the case of the petitioner is not one where the eligibility conditions are not fulfilled. The fact remains that the mismatch in the domicile district does not affect the eligibility of the petitioner, in as much as domicile district mentioned in the application form, as well as in the PRC, are both districts within the state of Nagaland and fall within the list of militancy affected district and border guardian district in respect of petitioner 1, 5, and 6. As per the said note appended such and such, the notice consequence of the post will be cancelled by the commission CAPF only on the ground of non-fulfillment of the eligibility condition. Now, may I take your lordship to the reply? Para 21. Page 12, your lordship.
Yes.
May I read down? That the content of para 13 petition is denied to the extent that the petitioners have mentioned incorrect district in the SSC online application form, which does not match with the indigenous inhabitant and PRC certificate. 22. That is the thing. That in reply to para 14 petition, it is submitted that due to mismatch of information, they have been returned home and matter taken up. They have not been returned home. In fact, the offer of appointment has been cancelled. Return and matter taken up with SSC through such and such Director General Service, on which decision is awaited. Now 23, that in reply to para 15 of the petition, it is submitted that since the petitioner did not mention the correct district they actually belong to, hence it does not match with the indigenous inhabitant and PRC. That is admitted, but with a mistake is bona fide. They have been returned back home and their mismatched case taken up with SSC, on which decision is awaited. But then final decision has already been taken by cancelling the offer of appointment. Now, your lordship may kindly see the last paragraph, page 13, para 25. That in reply to paragraph 17 of the writ petition is submitted that as the same has been examined in the ambit of the detailed guideline issued by SSC, SSC being the recruiting agency, further course of, this is the thing, commission being the recruiting agency, further course of action on this matter will be taken on the basis of direction issued by the commission, not see. That is their stand, your lordship. Now, in other words, your lordship, respondent number 5 is not the competent authority to cancel the offer of appointment, your lordship. By their own admission, they're saying that SSC being the recruiting agency, they will take the final decision, your lordship. Now, your lordship, similar issues, this has been all in their basis, your lordship. Similar issues was also taken up by a division bench of the Bombay High Court, your lordship. Oh, good. I'll just refer to this, just 5 minutes, lordship. I'll just. May I refer to paragraph 4? The writ petition 4761, your lordship, the first edition. This is Rajesh Hominath Nilakha versus Union of India by division bench. This is order dated 27 July 2020. Your lordship has got it. Now, may I take your lordship to paragraph 4? It is not disputed that petitioners was not to gain by writing domicile as Aurangabad instead of Jalna. This is also domicile PRC. In column number 24 and 25, petitioner has given postal and permanent address as district of Jalna. It appears that in column number 17, the petitioner has committed a bona fide mistake by mentioning district of domicile as Aurangabad. I've taken your lordship to that column because same advertisement. It does not appear the petitioner had intention of misleading nor would gain any advantage by mentioning district of domicile as Aurangabad. This is the same case, your lordship. Para 7. In case the petition is otherwise eligible, the respondent may not reject the candidature. This is a case where, lordship, their candidature was rejected at the time of DME, it appears, lordship.
6, para 6.
Para 6. Because the impugned order disqualifying the petitioner is quashed and set aside. 7. So in case the petitioner is otherwise eligible, the respondent may not reject the candidature of the petitioner for the post of constable only on the ground that the petitioner has wrongly mentioned the district domicile. This is the similar, your lordship. Another case in Andhra Pradesh, your lordship. The writ petition 3537 of 2021, your lordship. This is order dated 27 April 2022. Para 2, your lordship. The case of the petitioner is that pursuant to SSC notification number such and such issued by the second respondent, this is the same notification which I have referred to your page 62, your worship. Same notification calling for application to fill up the post of constable in CAFF, NIA, SSF for the year 2018. The petitioner applied for the post of constable such and such through online registration such and such and appeared examination and secured such and such. Now, relevant portion. Para 3. Now, page 2, your lordship, the second paragraph, fifth line from the bottom. Respondent number 2, fifth respondent issued the rejection order. Here also fifth respondent, your lordship has got it. Data such as that declaring the petitioner as disqualified on the ground that the petitioner has wrongly mentioned the place of domicile district in his application column at column number 17 in the online application. There's also a mismatch in district, your lordship. 3. The respondent filed counter affidavit and registered the claim made by the petitioner inter alia, containing that since the petitioner failed to produce certificate of his domicile district as per his fill-in online application, the candidature of petitioner for the post of constable GD was rejected and declared as disqualified as per the instruction of the notification due to variation of his district in his online application in reference to the certificate produced by the petitioner. It was further stated that notary affidavit submitted by the petitioner dated such as declaring that at the time of submitting online application, the district was mistakenly typed as Waterbury instead of Waterbury, and to consider his case was also rejected. Now, your lordship. Para 8, page 4. A perusal of the copy of the online application submitted by the petitioner, which is placed on record as material paper P2, appears that in column 17, this is the same column, your lordship, same application form. Petitioner committed the mistake of mentioning district of domicile as East Godavari, whereas in column number 24 and 25, the petitioner has given postal address and permanent address as West Godavari. This is same case as the present one, your lordship. Para 9. The learned counsel for the petitioner in support of his contention that the mistake committed by the petitioner is minor and insignificant, and hence the petitioner who is otherwise fully qualified be given an opportunity to rectify the mistake, relied on the following decision rendered by this. Para 10. In the above order, wherein the petitioner did commit the similar mistake of mentioning the district of domicile in column number 17, as was done by the petitioner, and then the petitions were allowed, giving direction to the respondent herein to permit the petitioner to participate in the selection appointment process, considering the mistake committed by the petitioner is an inadvertent error, your lordship. So accordingly, your lordship, the petition, para 12, accordingly, the petition is allowed and set aside the impugn order, your lordship. Now, your lordship, the selection, the process
These
is...
are all cases prior to the test. You have prepared the test.
Yes, your lordship. Now, here it was rejected, but mine was accepted. After having accepted, after giving offer of appointment, your lordship, then my offer of appointment was cancelled by an authority who is not competent to do, when the competent authority is yet to take a decision on the matter, your lordship.
So you are on a stronger footing than the other two petitions.
Yes.
From these two judgments,
in fact, I am better
we
placed.
see that they were disqualified earlier.
Yeah.
Prior to the test.
Yes.
You participated in all the tests, you were given appointment, you were allowed to join the force.
Offer of appointment.
And force number was given.
Yes.
And you asked to go back home till a decision is taken by the SSC. However, your appointment was cancelled.
Cancelled.
By the same order.
Yes.
Yes. Has the SSC taken a decision?
As far as my knowledge, no, not till now.
Why? More than a year has elapsed.
I have nothing much to say, but I'll just say that one part for my affidavit.
No, the issue is whether the decision has been taken by the SSC.
As far as
That is the only aspect left.
Yes, not.
Whatever decision the SSA takes, that's a different thing.
In fact, I may not go to the fact house, but if my lordship pass an order to whether SSA has taken the decision on it, as per the affidavit.
In the other two cases, you have taken a decision to disqualify them.
Yes.
All right. Therefore, they came to court. In this present case, they were successful in all the tests, all the medical examinations, which was the appropriate forum to have considered the PRC and the domicile address. They approved. Of course, in the note, it says at any point of time, even after joining,
yes,
this can be
If
verified.
found not eligible.
If found not
And
eligible.
domicile has got nothing to do.
That is that. Here you've given them appointment, ask them to join the force. They joined, give them the force number also.
Yes.
Then you had very for the time being, till the SSA takes a decision. Can you by the same order, can you cancel the appointment? One. Before canceling the appointment, did you hear the petitioners? Whether this cancellation or order is done by the appropriate authority. That's the whole thing.
Lordship, I'm given a short time to see whether the SSA have already.
This affidavit was filed on November 2022, if I'm not wrong.
In fact, your lordship.
Where's the affidavit? Yeah, here's the affidavit. This
21/11.
23rd November 2022. By then, at least you could have got some information. This writ petition was filed in
May, 5th of May.
May.
Your Lordship, earlier I have received the Barawas comment, but all the Barawas comments was in Hindi. So I have to send it back, get a translated copy, and already after I filed my affidavit.
No, that's fine. That's not the issue that you have
Yes,
filed
yes.
late or what. I'm not questioning on that. I'm questioning on the fact that you filed the affidavit in November. By then, the SSC should have taken a decision. At least you could have incorporated that in your affidavit or application so that it makes the work of the court easier.
No, in the affidavit, your lordship is clear that decision is still awaited.
That's why decision
It's
is still
still
awaited.
awaited.
Nothing is. Now, is the SSC going to keep on sitting like that? In the meantime, you cancel the petitioner's appointment, and in that same order, you say that till the decision is taken by SSC, you go back home and you wait. If you end there, that's fine. Petitioner would have to wait for the decision. But then with the next paragraph, you say your appointment order is cancelled. And whether that order was passed by the appropriate authority, competent authority. So if you want time, I can give you 2 days time maximum. You just have to make a phone call. Otherwise, I'm disposing of this.
You have to come up on 16.
16 is the last working
Yes,
day. I don't know.
Just to advise the court. Because
Okay.
the reports are not in.
Okay, heard TP Jamil and the counsel for petitioner. On request made by Gauhati and the CGC, list the matter on 16th as parted and also as first item.
And your lordship, in case if I cannot be there, 16, he will be there, first of all.
That's fine.
I much.
In the admission list. In the admission.
For admission, item number 22.
May I please, your lordship? Your lordship, here we are yet to file a reply, your lordship. For respondent number 5, your lordship. Lordship,
Who's respondent number 5?
Private respondent, Your Lordship.
Maybe 5 will have to be heard. Heard IMT and counsel for petition. On request made by M. Solo, Leonard, counsel appearing for respondent number 5. 3 weeks time is allowed to file counter affidavit. You file your affidavit early.
Lordship. Much obliged.
List after the identification.
For admission, item number 24.
No counter.
No. All are government respondents.
But in the Logjar, Leonard counsel for petitioner. None appears for the state respondents. It is a matter of concern that when sufficient numbers of government advocates have been appointed, there's no one to represent the state today in this particular case. Stop. However, it is the matter of after the winter vacation to enable the state respondents to file counter affidavit. Let today's order be brought to the notice of the Chief Secretary, Nagar.
Much obliged.
14 or 23?
14, Sergeant. Take up 23.
For admission, item number 23.
Please, Your Lordship. My Lord, this is second round of litigation between the parties. The same petitioner, same respondents for the second time. Lordship, kindly allow me to give a brief facts about the case. Now the issue will be, since this is the second round of litigation, the issue will be limited now. Lordship, the petitioner was declared successful in the interview conducted by the Nagaland Public Service Commission. The advertisement and Lordship, where she was declared, advertisement was in the year 2018, and she was declared successful for the post of Secretariat Assistant. She belongs to Sumi Naga community and an indigenous inhabitant of Kifri district, who are considered as who are entitled for certain reservation backward under backward quota for the Sumis of who hails from Kifri district, the indigenous inhabitants of Kifri district. Now, after she was declared successful to the post, the student community of that particular area, Susumi communities, lodged a complaint that I am not an indigenous inhabitant of a particular area. The claim is that I'm not a Naga. Now, thereafter, Lordship, an inquiry was conducted by the Deputy Commissioner of Kifri to ascertain the veracity of my indigenous inhabitant certificate. Now, what has happened, Lordship, is an unfortunate story. The petitioner's father's name is Juan Hotoshi. He developed an extramarital affair with a Nepali girl from Mukokchok. So she was born out of that relationship. After she was born, the mother's name was Mina. The wife of Mr. Hotoshi refused to accept her because he had many children by then. So what has happened? The aunt of the petitioners, who is Miss Srimati Yevili, and she was married to an Assamese, one Mr. O'Neill Rova, who was working as a fourth grade in the DC office, Mukokchok. So 2 weeks after her birth, she was taken by her mother, by her aunt, and she was brought up as an adopted children of Mr. O'Neill Rova and her aunt. And whereabouts about her mother is not known. In fact, the petitioner have never met her mother, and they have no idea about her whereabouts because 2 weeks the infant was taken from her and she left Mukokchok. That is the story. Now, what has happened is in all the official documents, her documents, starting from school's living certificates and in all the documents, her father's name is written as Mr. Hotoshi Somi, and her aunt, who brought her up, Miss Srimati Yevili, has been entered as her mother's name. No dispute about that in the record. So thereafter, in the pension book of Mr. O'Neill Rova, her uncle, who had brought her up as one of his own, she is included as a beneficiary in the pension book. Her name is not included as a beneficiary in the pension book of her father, Mr. Hotoshi. Though in the documents, he's shown as the father's name, as the father. In the mother's column, her aunt name, Srimati Yevili, is included. So an inquiry was conducted by the Deputy Commissioner Kifri, and my lord, only on the ground that her name is included in the pension book of O'Neill Rova, her indigenous certificate was cancelled, revoked. So in that view of the matter, the Nagaland Public Service Commission issued an order on 30/6/2020 whereby her name was, my lord, when I read the judgment, all these facts will be clear, but I would like to give a brief background so that your lordship get a sense of the issue. So the Nagaland Public Service Commission issued a notification in supersession of the earlier order, and against my name, the respondent number 6 was appointed as Secretariat Assistant. Now, my lord, in the recent exams conducted, the result declared last month, the respondent number 6 again appeared for the exam, and he is already selected for the same post as Secretariat Assistant against the reservation of Kifri Somi community. That is also subsequent development. In my reply affidavit, I have filed. So, my lord, I approached this honorable court. And this honorable court, in WPC 85 of 2020, my lord, I'll read the judgment. By an order dated 11/4/2020, has set aside the NBSC's order. And then, lordship, the finding of this honorable court was that principle of natural justice was denied to me. So the direction, petition was disposed of with a direction for the Deputy Commissioner Kifri to conduct detailed inquiry. And on the basis of the evidence on record, Deputy Commissioner to take a decision. That was the specific direction of this honorable court. There was no direction by this honorable court to conduct DNA test. And lordship, the honorable apex court judgment is very clear that DNA test is voluntary, it can't be imposed. I'll come to that later stage in the judgment of the Honorable Supreme Court. So, my lord, thereafter, my lord, evidence was taken by the Deputy Commissioner, and my lord, on 2011-2021 and 4/12/2021, detailed evidence were given, opportunities were given, so all the parties appeared before the learned Deputy Commissioner. Detailed inquiry was conducted. Thereafter, Lordship, my Lord, I have made a categorical statement in the petition. When inquiry was conducted, after inquiry was conducted, there is a lot of pressure from here and there, obviously. The Deputy Commissioner has asked the petitioner in her family whether he would like to go for DNA testing, because the other side were insisting that DNA test should be taken. So, my Lord, it is the categorical statement of the petitioner before the Deputy Commissioner that, look, we are not afraid of DNA testing. But since sufficient evidence has been taken on record for 2 days, and since there's no specific direction by this honorable court also for DNA testing, on the basis of the evidence on record, which was taken on Lordship 2011-2021 and 4/12/2021, this Deputy Commissioner should give his decision. That was our stand. Now, Lordship, it clearly admitted by the governor in the affidavit of the Deputy Commissioner, after the evidence was recorded, the petitioners were not allowed to sign. None of the depositions witnesses were allowed to sign in the records when the evidence were recorded. So, my Lord, we give our evidence, we left the place. Thereafter, the evidence were published, and this Deputy Commissioner had taken a decision to go for DNA test. Now, my Lord, in the affidavit of the government, they have clearly admitted that, yes, because of paucity of time and the fact that fair recordings was not possible, none of the parties, the petitioners as well as the others, were allowed to sign in the recordings and when the evidence was recorded. So, my Lord, thereafter, Lordship, Deputy Commissioner was an order dated 11/4/2022 and later dated 5/5/2022, which is under challenge that we should go for DNA testing, since he's not satisfied with the evidence taken on the first 2 days. So that is a brief background of this honorable court. So I have approached this honorable court. My Lord, I'll read the orders. So, my Lord, my prayer is this. I have filed this writ petition with a direction for setting aside the impugned orders. And, my Lord, initially, my Lord, I have prayed for a direction to the Deputy Commissioner for a decision, to take a fresh decision on the basis of the records available. However, my Lord, during the pendency of this writ petition, I have filed an IA. And, my Lord, prayer number 3A was allowed to be inserted by this honorable court, whereby, my Lord, I'm praying that, my Lord, the option is that on the basis of the records, for this honorable court to take a decision on the basis of the evidence recorded before the Deputy Commissioner. My Lord, I'll come to that later stage. That is the background. Now, my Lord, since this is the second round of litigation, my Lord, taking evidence, going to the new evidence on record, that stage is over because Deputy Commissioner, as directed by this honorable court, Deputy Commissioner has already recorded the evidence. And the earlier findings before the single bench is there. So, my Lord, the counsel for the private respondents has filed a lengthy affidavit including all the evidence and other reports. But in my respectful submission, we cannot go, that stage is over. So, my Lord, whether on the basis of the evidence before in the earlier order judgment passed by the single bench and the evidence recorded by Deputy Commissioner as directed by this honorable court, so, my Lord, subject matter should be confined to that limited purpose only. I'll confine to that, nothing more, nothing less. Now, my Lord, kindly allow me to read a certain portion of the judgment, then I'll go straight to the. Now, Lordship, may kindly allow me to see the interim impugned order, page 53. In compliance to this honorable court order dated 27/9/2022, the directing the state respondents to conduct a thorough inquiry in regard to the indigenous identity of Ms. Livy Sumi. The undersigned had heard all the stakeholders on 20 November 2021 and 4 December 2021. Minutes of the proceeding enclosed by giving the chance of producing their evidences, both oral and documentary, for better adjudication of the case. The undersigned, on being heard of the petitioner, is not satisfied with the evidence so produced. Therefore, it is hereby directed to conduct a DNA test of the following persons: Miss petitioner is serial number 1, petitioner number 2 is her uncle, and petitioner number 3 her father. Further, it is also stated that above-mentioned persons have agreed to undergo the DNA testing, and Eastern Sumi Hoho and Kifri District Union have agreed to bear the expenses incurred during the DNA testing. So this is the order. I'll come to my pleadings later stage, my lord. Then the next, lordship, I'm directed to forward herewith letter dated 4/3/2022, along with its enclosures received from the Directorate of Health and Family Welfare on the subject cited above, and regret to inform state that the state doesn't have DNA testing facility. Further attention is also invited to a letter even number dated 4 March 2022, where the state government had conveyed that the report decision of the Deputy Commissioner be placed before the High Court along with recommendation request for DNA test. You are therefore requested to take appropriate action, and if required for DNA testing, the 3 centers referred as such and such, Calcutta. Now there's an interim order. Then, my lord, next page is the interim order, the immune order, page 55. I'm inviting a reference to the subject section of that is, and as decided in the proceedings of the above-mentioned cases held on 4 December 2022 in the Court of Deputy Commissioner, you are hereby directed to undergo DNA testing before 20 July to expedite the case. It will be noted that the indigenous identity will be decided after DNA testing result is submitted. So, my lord, this is under challenge, and this honorable court has suspended these orders. Page 53 and 55, annexure F and annexure H. Now, my lord, I'm coming straight to the judgment. Thereafter, my lord, I'll read some of the pleadings, and my lord, I'll go to and make my submission. My lord, the imbued judgment, the first judgment, Lordship, may kindly go to annexure P, page 31. My lord, I am reading paragraph 2 and paragraph 6, 7, and 8. My lord, that this will be self-explanatory. My lord, it will save the time of making me lengthy submission. Page 32. May I read, my lord? Paragraph 2. The facts and circumstances leading to the filing of this writ petition briefly stated are as follows. In response to an advertisement dated 31/8/2018, wherein applicants were invited to fill up several vacancies in different services of the state government, including 40 posts of secretariat assistant, the petitioner herein also submitted her application and appeared in the examination conducted by the commission, and she was declared successful and thus recommended for appointment to the post of secretariat assistant. But soon after the selection and recommendation list of the candidates was declared, Kifri District Somi Students Union submitted a complaint dated 12/5/2019 to the Controller of Examination in NPSC requesting to nullify the indigenous certificate of the petitioner and to select a bona fide candidate from the Sumi tribe of Kifri District, claiming that the petitioner is not a bona fide indigenous citizen of Yongzitang Village, Kifri District. Thereafter, through newspaper publications, the student union continued to raise the issue, and clarification from the side the NPSC also followed, and that continued for a while. The matter then come to the notice of the government of Nagaland. Accordingly, the PNA directed the Deputy Commissioner Kifri to verify the genuineness of the indigenous status of the petitioner. Following the direction, the DC Kifri on 29/1/2022 held a meeting for verification after same, and the ambient order dated 16/6/2020, wherein and whereby the indigenous certificate of the petitioner, which was issued earlier by the Deputy Commissioner Kifri, file number dated 9/6/2020, registration such as such, was cancelled along with that of 2 more girls who were supposedly her cousin sisters / cousin sisters. Or, my lord, these two girls are the daughter of O'Neill Roba, but they are not before the Honorable Court. They are original daughters. They are daughters of O'Neill Roba, so they are not contesting the cancellation. Being aggrieved by the said order by the Deputy Commissioner Kifri, the petitioner is before this court praying for issuance of appropriate writ, quashing and setting aside the imbuing order in respect of the petitioner, and also for quashing and setting aside the notification dated 36/2020 issued in notification of the Commission's notification dated 12/9/2019 and 21/1/2020, whereby petitioner's names was deleted from the list of selected candidates and replaced by private respondent. Number 6, in further praying for directing the respondents to appoint the petitioners in terms of the notification dated 19/12/2019 issued by the NPSC. My lord, the extramarital affair, what that I have mentioned, I am deleting it, skipping it for the time being. Then lordship may come to paragraph 6, page 35. Considered the submissions of the learned counsel representing the parties and bureaus to record, including the affidavits filed. But before I go any further, the undisputed facts and contents of the imbuing order are given here below, one after the other. My lord, this will be very vital. 1. In the admit card of the petitioner issued by the NPSC for appearing the high school leaving certificate examination conducted in the year 2008, commencing from 15/3/2008, and the higher secondary school certificate 2010, commencing from 2010. The name of the petitioner was recorded as Levi Sumi. Levi Sumi, father's name as Hotoshi Sumi, and mother's name as Yuvili Sumi. Mother Yuvili Sumi is her aunt. No dispute. Father's younger sister. 2. In the indigenous certificate issued by the Deputy Commissioner Kifri dated 9/6/2017, the name of Hotoshi Sumi of Yangzidang village, this Kifri district is shown as her father, and she being a person belonging to the Sumi Kifri tribe of Kifri district. 3. The petitioner's birth certificate issued in form number 5 by the government of Nagaland's Economic and Statistics dated 12/5/1996, date of birth is shown as 5/1/1992, and her place of birth as Mokokchung, and her father's and mother's name as Hotoshi Sumi and Yevili Sumi, respectively. In the Aadhaar card of the petitioner, her date of birth is shown as 5/1/1992, her address as care of such and such, Sangtemla Ward. In the PAN card, such and such of the petitioner, the name of her father is shown as Mr. Hotoshi Sumi. 5. 6. In the pension book of O'Neill, husband of Yevili Sumi, name of the petitioner is also recorded as one of the nominees, but in the pension book of Hotoshi Sumi, the name of the petitioner is not included among the names of the nominees. 7. Mrs. Yuvili Sumi is wife of Mr. O'Neill and biological sister of Hotoshi Sumi. Now, my lord, this is the cancellation order issued first on 10 June 2020. Married, my lord. Consequent upon the complaint filed by the Kifri District Sumi Students Union to the government to nullify the indigenous certificate of Ms. Luvi Sumi, that she does not belong to the indigenous Sumi tribe of Kifri District, and the personal administrative reform letter dated 20 November 2019, and upon studying all the documents and facts pertaining to the case, the following have been found and concluded. Though Ms. Levi Sumi has listed her father as Hotoshi Sumi of Yangzidang village, Kifri district in her documents, including the indigenous certificate dated 9/6/2017, yet Mr. Hotoshi Sumi has not listed her name as his daughter in the pension documents issued by the Office of Accountant General. He has listed only his wife, locally at Sema, and stated her children as overage, even though Levi Sumi was an unmarried female and eligible at that time to be included in Hotoshi Sumi's PPO documents. Also, documents of Levi Sumi list Srimati Yuvili, wife of Onurova, as her mother, and who Srimati Yuvili, as per Aadhaar and EP cards submitted, appears to be the biological sister of Hotoshi, as she share the same father's name, Sri Zituku Sema. Also in the pension papers of O'Neill Rava, as per the Commissioner's letter dated 17 June 2003, O'Neill Rava has retired as a sweeper from the office of Deputy Commissioner Zonipoto on 2003 and clearly indicated his family as Yivili, wife Srimati Kavituli daughter and Mr. Levi daughter. From the above documentary evidence, it appears that Levi Sumi is the daughter of O'Neill Rava and not Hotoshi Sumi as claimed by her. Also along with Levi Sumi, Ms. Levi Tuli and Ms. Kavituli, who have named their father as Sri Hotoshi, has obtained an indigenous certificate at the same time from the office of Deputy Commissioner Kifri. However, it may be noted that Ms. Kavituli is also named in O'Neill Rava's pension documents as one of his children, along with Srimati Levi Sumi. In addition, all of them have given their mother's name as Yivili, whereas the pension documents of Hotoshi Sumi clearly names his wife as Lukuli Etsema, which clearly casts a top on their credibility as indigenous Sumi of Kifri. It is also highlighted that the said certificate was issued from the office of Deputy Commissioner Kifri on the strength of verification done by the then Village Council Chairman Yangsitang Village, Hotoko Sumi, in the official application from the issue of indigenous certificate, where it clearly shows that he shall be responsible for any false information furnished. This shows the callous attitude of the village authorities and failure on their part to perform their delegated assignments diligently while verifying officers and issuing authorities. Therefore, based on the compelling documentary evidence, indigenous identifying Ms. Lovisumi as Subinaga Kifri district by this office number dated 9/6/2017 is hereby cancelled. Also, Ms. Kavituli is named as one of children of O'Neill Rava in her pension documents. Therefore, based on the compelling documentary evidence, Ms. Kavituli's indigenous certificate, her name as Suminaga, is hereby cancelled. Also, Ms. Lovituli, who has named her father as Hotoshi Sumi, but also lists Srimati Yuvituli, wife of O'Neill Rava, as her mother in her documents, and which also caused a top on her credibility, and hereby her indigenous certificate is also cancelled for further scrutiny. So this was challenged. It appears from the submissions of learned counsel appearing for the parties and from the contents of the imbued order that the same was passed on mere perusal and partial consideration of the documents submitted by the parties involved. Further, it also appears that the imbued order was passed giving so much weightage only to the pension papers of O'Neill Rava and the husband of Sri Yivili, but totally ignoring the other documents, since there was a strong claim on the part of the petitioner that she was born out of an extramarital affairs of her father with another woman, and therefore, before she began adulthood, name of her father's sister was entered as her mother in her educational credential. Since it is a fact that there are also strong claims from Hotoshi himself that he is the real father of the petitioner, which is supported by Chairman and Secretary of the Village Council respectively, the Deputy Commissioner Kifri should have recorded evidence, put oral and documentary, and thereafter only through the conclusion whichever way the evidence supports. However, it appears from the imbued order that nothing of that was done, but based only on the face value of some documents, the fate of the petitioner was decided. The issue involved here are crucial to the very identity and future of the petitioner besides her career. Therefore, it requires careful consideration of all evidences that are available or can be produced by the petitioner and the opposite parties. However, sadly, it appears in the face of the record that Deputy Commissioner Kifri, in a hurry and arbitrarily, had drawn the conclusion and cancelled the indigenous certificate of the petitioner. Furthermore, in such cases by which the life of a person can change drastically, any authority responsible for taking such a decision is bound to give sufficient opportunity of being heard to the petitioner concerned. The right of being heard does not mean a chance of mere appearance of a person once or twice, rather includes giving of opportunity to produce all evidence, both oral and documentary, to prove one's case. But in this case, on the face of the record, it appears the opportunity was not given to the petitioner. This amounts to denial of right of being heard or violation of principle of natural justice. In a democratic system of governance, the right to be heard of a citizen is sine qua non of ensuring fairness and equity in administration. It is not possible to imagine maintenance of fairness and equity in administration without it. Therefore, in administration, it should be ensured that this principle of law is upheld at all costs. Viewing the imbued order of the Deputy Commissioner by taking into consideration the admitted facts and circumstances of the case in the preceding paragraphs and the principles of law stated above, this court is of the view that the same cannot be upheld. Therefore, it is quashed and set aside in respect of the petitioner hearing. Consequently, the Deputy Commissioner Kifri is directed to conduct a thorough inquiry by giving all the stakeholders or the parties involved the chance of producing their evidence, both oral and documentary, and of being heard, and thereafter draw a conclusion supported by evidences so produced. This should be done within a period of 3 months from today, and since one of the posts of SA cannot be filled up until the Deputy Commissioner takes a decision, as for the second imbued order that is 3/6/2020 issued by the NBSC, the same shall remain suspended till the Deputy Commissioner Kifri come to a conclusion on the issue of petitioner's indigenous identity. So, my lord, sums in substance, principle violation of principle of natural justice. So, setting aside the first cancellation order, direction was given for a thorough inquiry, both oral and documentary. Lordship. And the NBSC's post is kept reserved, and the imbued order notification is suspended till the Deputy Commissioner take the decision. Now, my lord, nowhere there is a direction by this honorable court to the Deputy Commissioner to conduct a DNA test by respectful submission. Now, thereafter, my lord, next page, 41 onwards, page 41 onwards. Evidence were taken. Now, my lord, on 2011-2021, this is the evidence. May I read, Lord? Deputy Commissioner Kifri verified the original documents of Ms. Livy Sumi and took attendance of all the stakeholders where the following persons were absent: O'Neill Rova, Mina, Kotoko. So, my lord, the documents of the petitioner, my lord, which is reflected in paragraph 6 of the judgment, was produced again and verified by the Deputy Commissioner. That is one. Thereafter, my lord, statement of Hotoshi Sumi. Hotoshi is the father. The following are the statements of Hotoshi Sumi. One, that Mina is the mother of Livy Sumi, who abandoned them after the birth of Livy Sumi. Two, that Yevili is the biological sister who rise up Livy Sumi. Three, that he doesn't know anything about the whereabouts of Mina, and hence he can't bring Mina to future court hearings. That Kevituli and Livituli are not his biological daughters, but the daughters of O'Neill Rova. That five, that he has 12 children. So this is the, my lord, statements of Hotoshi. Then statement of Livy Sumi. The following are the statements by Livy Sumi. One, that she filed a petition to High Court to revoke the cancellation of her scheduled tribe indigenous certificate by the then Deputy Commissioner, which was based merely on the pension papers of O'Neill Rova. That she is the adopted daughter of O'Neill Rova. That Mina is her biological mother and her biological father is Hotoshi Sumi, and she has been living in Mukchung for the past 29 years. And four, on being asked by the deported why she applied for ST only in 2017, she replied that her application for ST in 2017 was as per the directive of PNR Department notification dated 2016 for replacement of all format of ST to the new format. So, my lord, earlier also it is issued. Five, that under representation submitted by Eastern Sumi Hoho and Kifri to such and such, it is stated that he had a meeting with the village council Yong Zitang, where he concluded her indigenous identity is doubtful, whereas on the letter submitted by Yong Zitang Village Council, it is written that she is a bona fide citizen of Yong Zitang Village. So this is a statement of the petitioner lordship. Then statement of Yevili. The following are the statements by Yevili. One, that Hotoshi Sumi is her biological brother, whereas Livy Sumi is not her biological daughter, but she is simply the foster parent of Livy Sumi. Two, that ESH visited her place to verify and check the genuineness of the indigenous identity of Livy Sumi, but did not find any substantial records and documents. Then, my lord, statement of Yehetu, family member of Livy Sumi. The following are the statements made by Yehetu, family members of Livy Sumi. One, that Hotoshi had extramarital affairs and Livy Sumi was born out of wedlock. Two, that Yevili is not the biological mother of Levi Sumi. This is an independent witness. Then, my lord, comes the complainant statements. One, the following Isuka, AGS of such and such. One, the Kifri, such and such supports the 16 June 2020 order issued by Deputy Commissioner Kifri. Two, that the village council Yongzidong issued NOC to Hotoshi stating that he is a bona fide citizen of Yongzidong village based on erroneous name in the electoral records. Statement of Kohoto Yutomi advisor Eastern Sumiho. One, that Hotoshi claimed that he has 11 children in the High Court, whereas he is now claiming that he has 12 children. Two, that during the meeting with the Deputy Commissioner Kifri, Hotoshi claimed that in 1992 she was posted in Mogokchung, but as per the office record, it was found that she had transferred to Zaniboto. Three, that there is a witness in Mogokchung who can testify that Yuvili was pregnant with Levi Sumi, but this independent witness he could not produce. Statement of Nick Hoto, Precedent, Eastern Sumi Ho, that there are several complaints about the indigenous identity of Levi Sumi after the declaration of NBC exam result. Therefore, he tried to verify the genuineness and having unable to a conclusion. My lord, this is important. After he tried to verify the genuineness and having unable to come to a conclusion, keep representation to the government to settle the matter. Two, that the matter should be settled either through customary court by taking oath or through DNA testing. So DNA coming for the first time here in the statement of the complainant. Statements of Kivishi, Joint Secretary, that he fully supports the written statements submitted by ESH and KDT's SU in relation to the case. Then, my lord, next page. Statement of Simon Awumi, uncle of Levi Sumi. One, that on 29 January 2021, the two parties had a meeting in presence of Deputy Commissioner Kifri, where they agreed to settle the matter and that Hotoshi would declare in the newspaper that Levi Sumi was born out of wedlock. However, Hotoshi did not mention the statement that Levi Sumi was born out of wedlock while declaring in the newspaper on the personal request of Levi Sumi. After the press release by Hotoshi, the General Secretary of Eastern Sumi, who made a telephonic conversation with Simon Awomis, stated that ESH had identified a witness in Mogokchung to confirm that Yuvili was pregnant with Levi Sumi, but no evidence that witness was never produced. Two, the Eastern Sumi Ho was not satisfied with the press release, and hence the ESH traveled to Mogokchung to check the reports for the genuineness of the indigenous identity of Levi Sumi. During that time, O'Neill Rava clearly mentioned to the official of ESH that Levi Sumi is not her biological daughter. However, O'Neill Rava mentions Srimati Sumi, Levi Sumi is a nominee in his pension paper out of compassion. Three, on being asked by ESH why they are fighting the case only for Levi Sumi and not for Levi Tuli and Kavi Tuli, Simon Awami replied that Hotoshi is not the biological father of Levi Tuli and Kavi Tuli, but Hotoshi is the biological father of Levi Sumi. Hotoshi has been mentioned as the father of Levi Tuli and Kavi Tuli in the ST of documents of Levi Tuli and Kavi Tuli because O'Neill Rava has been adopted by Hotoshi. Statements of Vitoli, my lord, this is important. Daughter of Hotoshi. The following are the statements made by Vitoli. One, that Mina gave birth to Levi Sumi when Vitoli was 12 years old and she can clearly remember it. Two, that during the pregnancy of Mina with Levi Sumi, Hotoshi's wife inquired from Yuvili, the sister of Hotoshi, to confirm if Hotoshi is the father of the baby, to which Yuvili replied in the affirmative. That Levi Sumi was born in presence of Yuvili and Vituli. So, my lord, she said, I was 12 years old, I remember, and I was present when she was born, giving birth with my aunt. Statement of Anato, Precedent. The following are the statements of Anato. One, that he submitted representation to the government to nullify the NBAC results and appoint a bona fide citizen in place of Levi Sumi. One, that KT such and such fully supports all the representations submitted in relation to the case. Three, that in the pension paper of O'Neill Rava, Sunil Livisumi is mentioned as his daughter, whereas Livisumi is not mentioned as a daughter in the pension papers of the Hotoshi. 4. That Hotoshi declared all his children are of age when she could have mentioned Livisumi. 5. That Livisumi is not indigenous inhabitants of Yongzidong village. 6. That Yivili is the biological mother of Yivili is the biological mother of Livisumi. Hence, Hotoshi cannot be the biological father since Hotoshi is the biological brother of Yivili. Next, my lord, the statement of GB of Yongzidong, H. Yohoto. My lord, the petitioner belongs to Yongzidong village, so the GB of the village. The following are the statements by such and such. 1. That NOC was issued to Hotoshi because Hotoshi is a bona fide citizen of Yongzidong village. The Deputy Commissioner scheduled the next hearing on 12 December with the petitioner and defendant along with the following absentees. So this is the, my lord, first evidence. My lord, then page 45 onwards, the members present, as many as 22 people were present on that day. My lord, meeting minutes at 45, 46. This is the meeting minutes. Then, my lord, page 47 is the second round of evidence on, my lord.
Yeah, we will continue to.
Lordship, yes. After reading this, my lord, I'll go straight to the judgment. Then I'll make my final submission. Mayor Lordship. My Lord, kindly allow me to continue with Annexure D, page 47. That is the evidence recorded on the next day, that is 4th December 2021. My Lord, the district magistrate welcomed the members and took attendance of all the stakeholders involved in the case. One, statement of Levi Sumit. The petitioner gave statement. The following are the statements of Levi Sumi. One, that Mr. O'Neill Rova is not her biological father, but her foster mother. Two, that Yuvili is not her biological mother, but her foster mother. Then statement of O'Neill Rova. The following are the statements of O'Neill Rova. One, that he belongs to a Assamese community. Two, that Mrs. Yuvili is his wife. That she has 5 children, Mugali, Binali, Kavili, Lovili, and Vinitu. 4, that Hotoshi Sumi is the biological father of Levi Sumi, and that he doesn't have any information about the biological mother of Levi Sumi. 5, that he was posted as a sweeper in the office of Deputy Commissioner at the time of his retirement. That he retired on February 2003. And being asked why he did not mention his eldest daughter Mogali as his nominee in the pension paper, he stated that all the pension papers related works were done by his wife, and therefore the nominee was also entered by his wife. Statement of Yuvili. The following are the statements of Yuvili. 1, that she has 5 children, Mogali, Binali, Kavili, Lovili, and Vinitu. And being asked why he entered Kavi, Lovi, and Levi as nominees in O'Neill Rava's pension paper, he stated that Kavi and Lovi are the youngest in the family, and Levi, being her adopted daughter, was entered in the nominee since she was advised by some officers to enter the youngest in the family. Lordship, youngest in the family because retirement pension till 25. Statement of Simon, Hutoshi's younger brother. The following are the statements of Simon, that the petitioner did not bring Mina, family members, to the court because they have no information regarding Mina. Statement of Hotolo, ex-village council chairman of Yangzidang village. My Lord, the petitioners hail from this particular village. That she was a village council chairman of Yangzidang village from 2017 to 2020. That he appended his signature in the indigenous form of Yivi Sumin when he was a village council chairman. That Sri Yivishi, family member of Hotoshi Sumin, brought the indigenous form of Livi Sumi since Hotoshi Sumi was staying in Zonipoto at that time. That he appended his signature after referring the village electoral roll listed on number 157, where Hotoshi's name was entered as Z Heavy, and being inquired by the Deputy Commissioner about the mismatch of name. It was stated that Hotoshi was also known by the name of Z Heavy. That is the statement of the village council chairman. Statement of Hotoshi Somit. Following are the statements of Hotoshi Somit that he is also known by the name Z Heavy, which he changed to Hotoshi Sumi in 1971. That he was about 18 years in 1971. That he does not have any document to support that he was also known as by the name Z Heavy except the affidavit declaration. Statement of Ihodo H. Yiptomi, GB of Yangzidang village. The following are the statements of Ihodo H. Yiptomi, that Hotoshi is the biological father of Levi Sumi, that he knows Hotoshi from earlier days, and he is also known by the name Zihivi. So this is a statement of the Gangura village. Statement of Yangzidang villagers. Yangzidang villagers submitted a joint declaration stating that Miss Levi Sumi is the biological daughter of Hotoshi Sumi. So it is a statement by the villagers. May I continue, Lordship? Page 49. Statement of Hoiko L. Yiptumi, father of Piketo. My Lord, this is Hoiko L. Yiptumi is the father of respondent number 6.
Okay.
The following are the statements of Hoiko L. Yiptumi that he had a telephonic conversation with GB Ihoto on the day of declaration of NPAC result, wherein GB Ihoto clearly stated that Levi Sumi is the daughter of Yivili and O'Neill Rava. Statement of D. Anato, President, Students Union. The following are the statements of D. Anato that Yangzidang villagers were also confused about the indigenous identity of Levi Sumi, and therefore he suggested to forward the matter to the government. Statement of L. Hokito Yipto, Advisor ESH. The following are the statement of Sri L. Hokkaido Yiptomi, that after the NBC results was declared, Yangzidang village circulated information through WhatsApp that Levi Sumi is not Sumi by blood. After, this is crucial, my lord, after hearing all the stakeholders involved in the case, the DC District Magistrate decided to conduct DNA test, Levi Sumi, O'Neill Rava, Hotoshi Sumi, to which both parties agreed to comply. ESH and KTS agreed to bear all the expenses regarding the testing. Now, my lord, I'll make a reference special with regard this particular paragraph. I'll make a special reference to my pleadings. Now, my lord, except for Nikito, page 42. Except for Nikito, page 42, my lord, who is the president of Eastern Sumi Hoho, at page 42, second last paragraph, the number 2. The matter should be settled either through customary court by taking oath or through DNA testing. Except for the statement by President Eastern Sumi Hoho, none of the petitioners or any of the relatives, the father, foster parents, or the sister, anyone, or the independent witnesses from the village authorities, or from the other side also, none has talked about DNA testing except for Nikito. Now, my lord, I have made a categorical statement in my writ petition, which I'll read. That, my lord, there was a query by the Deputy Commissioner with regard to DNA testing. And, my lord, we have made a category, and to that the relatives and the petitioner made a statement that we are not afraid of DNA testing, but since, as directed by this honorable court, the sufficient evidences have been taken, issue should be decided on the basis of the DNA testing. Now, my lord, may kindly come to paragraph 5 to my writ petition, page 12. My lord, I'm reading the page 12, 13 to save time. Lordship, I'm reading the paragraph at page 13, subparagraph. It is also respectfully stated, may I read from there? It is also respectfully stated that the complainants had failed to produce any concrete evidence, both in oral and documentary, to refute the claims of the petitioner. The complainants had only insisted upon DNA test of the petitioner, her father, and uncle. It is also respectfully stated that when the Deputy Commissioner Kifri had asked the petitioner, her father, and uncle with regard to DNA testing, the petitioner, allowing her father and other family members, had categorically stated before the Deputy Commissioner on 4/12/2021 that they are not afraid of undergoing DNA testing. However, the demand for DNA testing is arbitrary and unreasonable, since a detailed inquiry had already been conducted by the concerned authority after giving sufficient opportunities to all the stakeholders to give their evidence, both oral and documentary, etc. It was the stand of the petitioner that since there are sufficient materials available to decide the issue before the Deputy Commissioner Kifri, it is not necessary to undergo DNA testing. However, the petitioner and her family was much surprised and shocked that in the meeting minutes dated 4/12/2021, the Deputy Commissioner Kifri had decided to conduct DNA tests of the petitioner, her father, and uncle. It is also wrongly mentioned that they had agreed to comply. It is categorically stated that Deputy Commissioner Kifri did not ask for consent of DNA testing of the petitioner, her father, and uncle on 4/12/2021, nor at no point of time the petitioner, the father, and uncle had given official consent for DNA testing. The petitioner most respectfully states that during the proceeding held on 20/11/2021 and 4/12/2021, all the stakeholders were only allowed to sign in the attendance sheets. After the recording of their statement deposition, it was not read out to them. Also, the minutes of the proceeding held on 20/11/2021, 4/12/2021 was never read out to them and not allowed to append their signatures. As such, the minutes of the proceedings were recorded and circulated after unilateral finalization by the Deputy Commissioner himself. It is also stated the proceedings was not officially circulated in the time, and the petitioner was given the copies on request through WhatsApp recently. As such, he did not get the opportunity to rectify lodged complaint against the wrong recordings in the minutes dated 4/12/2021 with regards to DNA testing. 6, the petitioner respectfully states that such and such, my lord, to this, Lordship may kindly read the reply, paragraph 7 of the respondent's number 1 to 4. Page 5, paragraph 7. This is a Deputy Commissioner's affidavit. May I read, my lord? That with regard to the statements in paragraph 5 of the petition, the unstaying dependent speaks to state that the statement given by Hotolo X VCC that Livi Sumi is the biological daughter of Hotoshi Sumi is top false, since she was the one who had certified in the official application form that Ms. Kavituli and Ms. Livituli are the daughters of Hotoshi Sumi, who in reality they are the daughters of Onil Rova. The illegitimate action of the village authorities cast a doubt on all the claims in declaration of Yangzitang villagers, wherein they declared that Livi Sumi is the biological daughter of Hotoshi. That the detailed inquiry was conducted, giving opportunity to all the stakeholders to keep their evidence both oral and documentary. However, the petitioner could not produce new documents except the documents which are already submitted to the then Deputy Commissioner Kifri, and claims orally were given were not supported a valid written document. The respondent number 4 could not come to a conclusion since the documents available were not sufficient enough to decide on the indigenous identity of Ms. Lovi Sumi. Therefore, the respondent number 4 could not come to a conclusion since the documents available were not sufficient enough to decide on the indigenous identity of Ms. Livi Sumi. Therefore, the respondent number 4 had arrived at a finding that in order to come to a logical conclusion to address the issue, DNA tests of Livi Sumi's Onil Rava and Hotoshi Sumi had arisen. However, the said steps were taken only when the petitioner agreed to the suggestion to go for DNA testing in the meeting held on 4/12/2021. That the answering deponent picks to states that petitioner and the petitioner and her supporting witnesses were never prevented to append their signatures on the minutes of the proceeding. It was impossible to make the minus fair on that day itself due to time constraint, and for the matter, their signatures could not be appended. In fact, the respondent number 4 on humanitarian ground did not summon the entire family from Mogukchung to Kifri just to append the signatures, since they have already agreed to undergo DNA testing. So this is the clear admission by the Deputy Commissioner that we were not given an opportunity to append our signature during our depositions. Now, Lordship, before I go to legal submission, the respondent number 6 had raised a question of maintainability on the ground that the complainant, the Western Sumi Hoho, and the Students' Union were not implemented as a party respondent here, who are the complainants. But in my respectful submission, that issue is already settled in the first writ petition itself. They were the complainants, they were not a party, the petitioners, government, and the respondent number 6, who has been appointed in my place. So that issue is already settled. Secondly, Lordship, an issue was raised by respondent number 6 that the minutes of the Deputy Commissioner on 4th December, by which the Deputy Commissioner had decided to go for DNA testing, is not challenged. To that, my respectful submission, my lord, that decision, that minutes is already merged in the main notification, which is under challenge. The notification by which the Deputy Commissioner has ordered for DNA testing, which is communicated to me, that is page 53. So, my lord, minutes, the evidence has been, Lordship, the evidence has been, that particular evidence is already, my lord, merged by the main order, in the main order, that is 11/4/2022, which is under challenge, which is the basis under, because, my lord, unless a formal order is challenged or issued, my lord, it culminates with an order. My lord, action will arise only, it culminates through an order. Now, my lord, kindly allow me to read the judgment, then I'll conclude with my legal submission. My lord, I have given a Xerox copy the other day.
Here?
Yes, that is Ashok Kumar versus Raj Kopta, 2021, 1 SSC 20, it must be there.
Yes.
Yes. Now, my lord, kindly allow, this judgment has laid down the principle for DNA testing with regard to paternity, lordship. Now, my lord, I'll read from paragraph 7. In fact, my legal submission was almost covered with this judgment.
Yes.
The pleadings were exchanged quite early in civil such and such, but only after closure of the plaintiff evidence, the defendants filed an application on 17/4/2017 for subjecting to test plaintiff to a DNA test. The question is whether in a declaratory suit where ownership over co-personal properties is claimed, the petitioner against his wishes can be subjected to the DNA test. The related question is whether the plaintiff, without subjecting himself to a DNA test, is entitled to establish his right over the property in question through other material evidence. The timing of the application is quite equally relevant. The plaintiff had already laid evidence from his side to prove relationship between the parties, and at this stage, whether High Court should have directed the plaintiff to undergo the DNA test. Another issue of concern is whether, in the absence of a consent, a party can be forced to provide sample for a DNA test. Then, my lord, I am reading paragraph 9. While reconciling two earlier decisions of this court on the point of negative prescribed that there is no conflict in decision of such and such, it has been laid down that the courts in India cannot order blood tests as a matter of course.
You're reading?
Paragraph 9. There is no conflict. I'm quoting the.
Okay. Yes.
There is no conflict, my lord, because the item number paragraph 8 judgment is about section 112 Evidence Act, which is not applicable in the present case. I'll justify. Section 112, my lord, is that anybody in a wedlock after separation, if any child is born within 280 days after separation, the child is presumed to be the children of that family. That is 112, section 112, so which is not applicable here. There is no conflict in two decisions. It has been laid down that courts in India cannot order blood tests as a matter of course, and such prayers cannot be granted to have roving inquiry. There must be strong prima facie case, and the court must carefully examine as to what would be the consequences of ordering the blood test. In Sharda, while concluding that the matrimonial court has power to order a person to go a medical test, it was reiterated the court should exercise such power if the applicant has a strong prima facie case and there is sufficient material before the court. Obviously, therefore, any order for DNA test can be given by the court only if a strong prima facie case is made out for such a course. The learned single judge, while noting that sensitivities involved with the issue of ordering a DNA test, opined that the discretion of the court must be exercised after balancing the interest of the parties and whether a DNA test is needed for just decision in the matter, and such direction satisfy the test of imminent net, and such where the court noticed from the facts that husband alleged infidelity against his wife and questioned the fatherhood of the child born to his wife. In those circumstances, when the wife had denied the charge of infidelity, the court opined that but for the DNA test, it would be impossible for the husband to establish the assertion made in the pleading. In these facts, the decision of the High Court in order for DNA testing was approved by the Sovereign Court. In such and such, writing for the division bench considered it appropriate to record a caveat to the effect that the wife may refuse to comply with the High Court direction for the DNA test, but in that case, presumption may be thrown against the party. In circumstances where this is important. In circumstances where other evidence is available to prove or dispute the relationship, the court should ordinarily refrain from ordering blood tests. This is because such tests would impinge upon the right of privacy of an individual and could also have major social repercussion. Indian law leans towards legitimacy and frowns upon bastardy. The presumption of law of legitimacy in child cannot be rightly repealed. My lord, paragraph 11, I'm heavily relying upon. Then, my lord, I'm reading paragraph 13 onwards. The presumption of legitimacy of a child can only be displaced by a strong preponderance of evidence and not merely by balance of probabilities. The material portion of the court's opinion is produced here and below, but at the same time, the test of preponderance of probability is too light as that might expose many children to the peril of being illegitimized. If a court declares that the husband is not the father of his wife's child without tracing out its real father, the fallout on the child is ruinous, apart from all the ignominy visiting his mother. The bastardized child, when grows up, would be socially ostracized and can easily fall in the wayward life. Hence, by way of abundant caution, and as a matter of public policy, the law cannot afford to allow such consequences befalling on innocent children under the strength of mere tilting of probability. Its corollary is that the burden of the plaintiff husband should be higher than the standard of preponderance of probabilities. The standard of proof in such cases must at least be of a degree in between the two, as to ensure that there is no possibility of the being child conceived through the plaintiff husband. It was also the view of the court that normal rule of evidence is that the burden is on the party that asserts the positive. But in instances where that is challenged, the burden is shifted to the party that pleads the negative. Keeping in mind the issues of burden of proof, it would be safe to conclude that in the case like the present, the court's decision must be rendered only after balancing the interests of the parties, that is the quest for truth, and the social and cultural implication involved therein. The possibility of stigmatizing a person as a bastard, the ignominy that it attaches to an adult who in the mature years of life is shown to be not the biological son of his parent, may not only be a heavy cross to bear, but would also intrude upon his right of privacy. DNA is unique to an individual bearing twins and can be used to identify a person's identity, trace familial linkages, or even reveal sensitive health information. Whether a person can be compelled to provide a sample for DNA test is much in such matter can also be answered considering the test of proportionality laid out in a unanimous decision of this court in such and such, wherein the right to privacy has been declared a constitutionally protected right in India. The court should therefore examine the proportionality of the legitimate aims being pursued, that is, whether the same are not arbitrary or discriminatory, whether they may have an adverse impact on the person, and that they justify the encroachment upon the privacy and personal autonomy of the person being subjected to the DNA test. It cannot be overlooked that in the present case, the applicant to subject the plaintiff to a DNA test is in a declaratory suit, and the plaintiff has already adduced evidence and is not interested to produce additional evidence, DNA, to prove his case. It is now the turn of defendants to adduce their evidence. At this stage, they are asking for subjecting the plaintiff to a DNA test, questioning the timing of the applicant. The trial court dismissed the defendant's application, and we feel that it was the correct order. In the yet to be decided suit, the plaintiff had led evidence through sworn affidavits of the respondents, his school living certificates, and his domicile certificates. Significantly, respondent number 1, who is one of the 3 siblings, had declared in her affidavit that plaintiff was raised as a son by her parents. Therefore, the nature of evidence to be adduced by the plaintiff by providing DNA sample need not be ordered by the court at the instance of the other side. In such kind of litigation where the interests will have to be balanced and the test of imminent need is not satisfied, our considered opinion is that the protection of the right to privacy of the plaintiff should get precedence. Having answered this question, an additional issue to be resolved is whether a refusal to undergo DNA testing amounts to other evidence, or in other words, can an adverse inference be drawn in such a situation. In such a case, a three-bench judge of the opinion written by such and such in para 17 that if despite an order passed by the court, a person refused to submit himself to such a medical examination, a strong case for drawing an adverse inference can be made out against a person within the ambit of 144 of the Evidence Act. The plaintiff here had adduced his documentary evidence and is disinclined to produce further evidence. He is conscious of the adverse consequences of his refusal, but is standing firm in refusing to undergo the DNA test. His suit eventually will be decided on the nature and quality of the evidence adduced. The issue of drawing adverse evidence may also arise based on that refusal. the court is to weigh both sides' evidence with all attendant circumstances and then reach a verdict in the suit. And this is not the kind of case where DNA test of the plaintiff is without exception. The respondents cannot compel the plaintiff to adduce further evidence in support of the defendant's case. In any case, it is the burden on the litigating party to prove his case, adducing evidence in support of his claim, and the court should not compel the party to produce his case in the manner suggested by the contesting parties. Now, my lord. So, my lord, the petitioner from day one, my lord, subject to repetition, this court, in the first round of litigation, that is WBC 85/2020, by a judgment dated 27/9/2021, which we have gone through, right? There was the direction was opportunity has not been given, so direct both the parties, Deputy Commissioner Kifri, to conduct both oral and documentary evidence, and on the basis of the materials available, take that decision. That was the direction. Nobody has challenged it. That judgment has attained finality. We went to the court before the Deputy Commissioner, and thereafter, my lord, evidence was taken for 2 days on 20/11/2021 and 4/12/2021. Evidence we deposed before the Deputy Commissioner for 4 whole days. Full opportunity were given to submit evidence, both oral and documentary. The petitioner has submitted her documents, and orally, my lord, both the petitioner, then the family, and the independent witnesses. Similarly, the complainants and the father of respondent number 6 also deposed. At no point of time, my lord, we have agreed for DNA test, nor it was our position, deposition stand before the Deputy Commissioner. And on a query, we have said, subject to repetition, look, we are not afraid for DNA test, but after we have taken full evidence for 2 days, and after concluding of the evidence, Deputy Commissioner is insisting for DNA test. We said, we are not afraid for DNA test, but that stage is over. Sufficient evidence is there, kindly make a decision. That is our simple stand. And, my lord, subject to repetition, on both occasions, the evidence which was recorded was not read out to us, nor we were asked to sign. After everything is over, my lord, when we were supplied to us through WhatsApp, the categorical statement we have mentioned in paragraph 6, which the respondent Deputy Commissioner have not denied. That is the situation. And, my lord, I'm making a submission again today that petitioner is not willing to go for DNA testing, and that cannot be imposed upon me.
Yes.
And my respectful submission is that on the basis of the evidence recorded by this honorable court, when the judgment was delivered in 2020, my lord, I have read all the relevant paragraphs, the documents, the undisputed facts. Then the evidences, independent evidences, both sides, evidences recorded on, my lord, on the 2 days, 4/12/2011/2021 and 4/12/2021, there are sufficient material evidence to prove that the petitioner is the daughter of Hotoshi Sumi, who belongs to Yangzidang village and an indigenous inhabitant of Sumi community of Kifri area. And accordingly, my lord, the manner in which my indigenous certificate was cancelled is most arbitrary and illegal, and the direction given for DNA testing, my lord, cannot stand the test of law. In simple sums and substance, my lord, that is the issue. And, my lord, reiterating the submission, the findings in the findings, my lord, the Honorable Supreme Court has clearly laid down that presumption in law of legitimacy of a child, para 11, I'm reading again, para 11 of the judgment. In circumstances where other evidence is available to prove or dispute the relationship, the court should ordinarily refrain from ordering blood tests, and this is because such tests impinge upon the right of privacy of an individual and could also have major social repercussions. Indian law leans towards legitimacy and frowns upon bastardy. The presumption in law of legitimacy of a child cannot be rightly repelled. So my respectful submission, besides other paragraphs heavily relying on paragraph 11, there is sufficient evidence recorded, both oral and documentary, my lord, in favor, and presumption is in my favor. So, my lord, and the Honorable Supreme Court has laid down that when somebody is complaining, it is for them to disprove or to prove that I'm not a legitimate child of Hotoshi. That is what the Honorable Supreme Court Lordship has just read. So my respectful submission, my lord, is that the impugned orders should be quashed and set aside because it is in clear violation of my right to privacy, and at no point of time I have consented. And Lordship, the Honorable Supreme Court judgment, relying on the Supreme Court judgment. Now, my lord, on the second prayer, initially, my lord, Lordship may kindly see the prayer. It was only prayer number 3. My lord, prayer number 1 and 2, my lord, that is to quash and set aside 2 impugned orders. Prayer number 3 will direct the Deputy Commissioner to decide the issue on the basis of the evidence available, both oral and documentary, of all the stakeholders taken on such and such in a time-bound manner for the ends of justice. Thereafter, my lord, on 21/11/2022,
1 minute, your prayer 3.
3A, my lord, that is amended by an IA number 144, and then the registry was directed to record by hand. So that will be there, Lordship. The other day it was shown, 3A.
3A.
Yes. My lord, after yes.
Why is it not here?
May I read, my lord? Humbly pray that this report on the basis of evidence available on records, and especially on the basis of the evidence available both oral and documentary of all the stakeholders taken on 2011-2021 and 4/12/2021 before the Deputy Commissioner Kifree, and take a final decision on the status of the indigenous independence certificates of the petitioner, and please to direct the Deputy Commissioner to restore the indigenous certificates such and such. My lord, my respectful submission. This matter should come, my lord, the petition, we are fighting this case since 2020. And my lord, the mental trauma and a lot of issues involved. And my lord, the petitioner is also, my lord, she is also in a very unique position, my lord, in view of non-finalization of the case. She is also getting over age. Either she cannot apply this way or that way. Also, Lordship, even if the matter is remanded back, whatever decision, again, it may come back again to this honorable court. And evidence is already there, and the Deputy Commissioner also has expressed in the affidavit file his inability to take a decision. My lord, the opinions of the Deputy Commissioner is clearly apparent in the affidavit filed by him. So in my respectful submission, Deputy Commissioner will be predetermined if it is reverted back. So my respectful submission, this honorable court, for the ends of justice, have the power under 226 to mold the relief. So my lord, that's how, my lord, I filed an IA for amendment, so to give to aid prayer number 3A for the ends of justice. If I'm not indigenous, then I'll go and look for jobs as a general category. If I'm indigenous, then, my lord, I should get the benefit. So, my lord, not to keep it hanging for a long time. And Lordship, you kindly allow me to refer to my reply affidavit. Affidavit in reply to 1 to 4, as well as 6, but my lord, reply affidavit 1 to 4 will suffice. page 8.
Yes.
My lord, the respondent number 6 had already appeared for exams, and on 15 November 2022, the result were declared, and my lord, the respondent number 6 names as serial number 10, page 10, serial number 33.
Serial number?
33, PK2H. So, my lord, and that is backward tribe Sumi Kifri. Lordship, you can see in the column. So, my lord, he is already selected again. So the question comes, my lord, whether the respondent number 6 will be allowed to enjoy the best of both the worlds. Either he should accept the outcome of this case, or he should accept the results of 2022 where he is already selected. Because he cannot be appointed in 2 posts.
Initially, he was appointed as?
My lord, he was appointed Secretariat Assistant in my place. In my place, for the same post, where in my place. Because initially I was selected, that was set aside, and he was appointed, and which was under challenge. Which was challenged. That's how, my lord, the last paragraph, where, my lord, in the judgment, post is kept reserved. 1 post is kept reserved in the single bench judgment. My lord, page 40 to the writ petition. My lord, if your lordship may kindly read the whole facts at page 2, then everything is given. Initially, I was selected, and because of the complaint after the inquiry, it was my indigenous independence certificate was cancelled, revoked. In that view of the matter, the original NBEC result was modified. So in supposition of that, the petitioner respondent number 6 was appointed. Accordingly, we came before this honorable court, and accordingly, my lord, the order dated 30/6/2020, by which my appointment was superseded in favor of respondent number 6, is kept under suspension at page 40. So during the pendency of this writ petition, the private respondent 6 had appeared in the interview. No issue. I have no issue about that. But fortunately selected. So, my lord, the issue is now, by appearing in the second exam and getting selected, is that a clear case of waiver of his right in the present writ petition? That is my respectful submission, but action speaks louder than words. Because he cannot be appointed in both the vacancies. He can be appointed in one, no issue about that. So that aspect of the matter, my lord, that aspect
Issue is this court sitting on the Article 226.
Yes.
Cannot give a declaration with regard to your status. Yes. It has to be done by the competent authority.
My lord.
So maybe we can issue a direction that it should be within a specific period of time, 3 weeks, 4 weeks maximum, and pass appropriate orders. That's
my
the
lord,
thing.
my lord, I leave it to your lordship. But as a matter of abundant caution, I have amended the writ petition because,
No,
my lord,
I understand what you're saying, but it will be difficult for this court to declare your status.
my lord, I leave it to your lordship. I have no issue on that, but it is my lord, it is my duty to persuade your lordship. Yes. That's why I'm persuading. I'm persuading your lordship. But my respectful submission that in any case, my lord, the direction for DNA testing cannot stand the test of law. That is one aspect of the matter, lordship. One aspect of the matter, and my submissions. My submissions, my lord, on the basis of the judgment of the Honorable Supreme Court is another aspect of the matter. Thirdly, lordship, going by the affidavit of the Deputy Commissioner's affidavit. My lord, Lordship may kindly go to the affidavit of respondent number 1 to 4. So, my lord, if any direction has to be given, then, my lord, the decision of the deputy commissioner should not be influenced by his affidavit. Independent decision, not influenced by the stand he took in the affidavit. That is my humble request, because if that is not observation is not given, my lord, then we may come back again. You will only prolong. And secondly, lord, so my lord, and thirdly, lordship, and finally, lordship, the subject to repetition, the stage for taking evidence is over. The deputy commissioner should not be taking further evidence, because as directed, evidence is taken final. So, my lord, my respectful submission is, on the basis of the evidence recorded on 2011-2021 and 4/12/2021, that the deputy commissioner Kifri may be directed, if you, in the course with wisdom that is proper, to take his decision in a time-bound manner, keeping in view, my lord, the interests of all. Much obliged, lordship.
May I please, Your Lordship? My lord, my submission will be confined to the issue of impugn order.
Yes.
Very short submission, my lord. My lord, as per the direction given by this honorable court, inquiry has been conducted. Yes, in the order, there is no specific direction to conduct the DNA test, but discretion was given to the authority to conduct the inquiry. So, everything, opportunity was given to all the stakeholders, but by perusing the documents produced by the petitioner and all, the respondent could not take the decision, because there is credibility of doubts, because in all the documents, it has been written that father's name is Otose, mother's name is Yevili. And in the pension book of that the father named the Onal Raba, it is mentioned in the nominee has been mentioned, that petitioner has been mentioned as nominee. And in the pension book of the Hotose, that petitioner name is not reflected. So, my lord, here, in my affidavit, your lordship may kindly see in para 12.
Yes.
The ground for issuing of impugn order. May I read, my lordship? That with regard to the statement made in paragraph 10 of the writ petition, the answering deponent denies the same, and the petitioner is put in strict proof that only after a thorough inquiry was conducted as the Honorable High Court order dated 27/9/2021, and to arrive at the logical conclusion that the process for DNA test was initiated. On perusal of the High Court order dated 27/9/2021, there is no such direction by the Honorable Court not to conduct any DNA test. However, discretion was given to conduct fresh inquiry and decide the matter according to his finding. Therefore, the steps taken by the respondent number 4 cannot be termed to be arbitrary and in violation of right to privacy. It is a settled principle of law laid down by the apex court that there must be a strong prima facie case and should not be against his or her will while the direction for blood testing has been issued by the court. It is also further observed that the blood group testing is a perfect test to determine caution of disputed paternity of a child and can be relied upon by the court as a circumstantial evidence, which ultimately excludes a certain individual as a father of the child. In the instant case, the prima facie of the case is that, firstly, the answering deponent has cancelled the indigenous and settled caste certificate of the petitioner and her two other sisters, but the petitioner is the only person who is before the court. And also during the course of inquiry and interrogation, Mr. Hotose Suimi has categorically testified that petitioner is his daughter, but the other two sisters are not his daughter. Whereas in all the education documents or official documents, all three of them are using the father name as Mr. Hotose Sumi and mother name as Yevili Sumi. And whereas Hotose Sumi and Yevili Sumi are biological brother and sister. In fact, Yevili Sumi, petitioner mother, is the wife of Mr. Onil Rawa. Secondly, there was written proof, pension book, that the petitioner is the biological daughter of Sri Onil Rava. If the petitioner biological father is Sri Hotose, then he could have nominated Miss Levi Sumi in his pension papers, whereas he had not whereas he had mentioned that his children are overage. Likewise, if Onil Rava is not her biological father, then he could have nominated his second daughter, Miss Levi Tole, and not Miss Levi Sumi. Thirdly, on 4/12/2021, the petitioner Hotese and Onil Rava was consented to undergo DNA tests, consented in front of all the stakeholders. As such, the impugned letter dated 5/5/2022 was issued considering all the facts and circumstances of the case and not against the will. It was all initiated in accordance to the procedure established by law. My lord, petitioner, they are also making submission that they are not afraid to go for DNA test. So in the meeting, in the during the course of inquiry, the petitioner and the other two also agreed to go for DNA test. So, my lord, here, until and unless the paternity, the dispute of paternity of child is decided, it is very difficult to take the decision. So, that issuing of that impugned order is also a part of inquiry. So, until and unless that is decided, it is very difficult. So, my lord, and that issuing of impugned order also directing to conduct the DNA test was issued after obtaining the approval, my lord. The lordship,
After obtaining the approval of what?
Of the petitioner and one.
This is the dispute here, no?
Yes, my lord. So, as per the Supreme Court cases, it's very clear that when the consent has been obtained, the DNA case can be conducted. Your lordship, kindly, I want to refer the judgment 1993 3 SSC 418.
1992, 3 SSC.
3 SSC 418. Para 16. Para 16, para 2, sa para. I have highlighted, your lordship, may I read, my lord? There is another aspect of the matter also. Before a blood test of a person is ordered, his consent is required. The reason is that this test is a constraint on his personal liberty and cannot be carried out without his consent. Whether even a legislature can compel a blood testing is doubtful. In para 17, in Hargovin Soni versus Ramduri, it was held. The blood grouping test is a perfect test to determine questions of disputed paternity of a child and can be relied upon by court as a circumstantial evidence. But no person can be compelled to give a sample of blood for blood grouping test against his will, and no adverse inference can be drawn against him for this refusal. Para 18. Blood grouping test is a useful test to determine the caution of a disputed paternity. It can be relied upon by courts as a circumstantial evidence, which ultimately exclude a certain individual as the father of the child. However, it requires to be carefully noted, no person can be compelled to give sample of blood for analysis against his or her will, and no adverse inference can be drawn against him or her for this refusal. So, basing on the approval given by the petitioner and the two others, that impugned order was issued. So there is no illegality in issuing that impugned order. That is my limited submission, my lord.
One thing is,
Yes. Yes, Gautam
My
Kundu.
lord, this 1993 judgment is referred here.
yeah,
That is my humble submission, my lord.
your para 7. It says that you could not finalize the minutes or the proceedings of that day,
Yes, my lord.
and then you could not call them from Kifre,
Yes.
from Mokchung again.
Yes, my lord. For signing the meeting
For
minutes.
signing the-
Yes.
And the issue is this: if they don't agree to a particular line which is inserted in that proceeding,
Yes.
they obviously will not give the signature to that proceedings. Now that opportunity was also not given to them.
My lord, in the meeting,
1 minute.
my lord, in meeting minutes was all handwritten. It was recorded handwritten.
It was
That is
recorded
so-
in handwritten,
Yes,
and
so
then
that is
that's why you said you could not finalize
Yes,
that day.
yes, my lord.
So
Yes.
the parties left
Yes.
for their respective districts.
Yes, my lord.
And then it is your own statement
Yes, my lord.
that you did not want to call them from Mokchung again, considering the distance and all this.
Yes.
Correct?
Yes, my lord.
Supposing if you have called them and they came, and they saw that particular line that for so and so DNA testing so and so, which is recorded there. Supposing they read that and they say, no, this is not the what we have said, and therefore we are not signing this. Now what would you do? This one aspect this court has to consider.
Yes, my lord.
particular.
But here we have already stated what.
Otherwise,
what-
this judgment,
Yes.
this judgment goes in favor of the petitioner, the one which you have referred.
Yes.
So the main thing is,
Supposing I answer your averments in paragraph 7 in the negative,
yes.
this goes in petitioner's favor. I'm not taking a decision. I'm not taking a decision
Yes,
now.
my lord, whatever the reason we have already stated in the affidavit.
That I've
Yes, my lord.
considered.
We have already, that is the reason, my lord.
Okay. Any more?
That's all.
May it please my lord, lordship, here, if we go outside the purview of the law and the way the petitioners are misleading and committing perjury, it's unbelievable. Lordship, on the day when that, I was also, since it was the matter I took up and the statement, all those 4th December and all conclusion came in the evening, I was always informed by my clients as to how the proceedings went. It was they have also stated now they are trying to make it moderate, or we are not afraid of DNA testing. They are stating that, but before that there are more than how many signatures are here, lordship, in front of the whole meeting, both the parties. They say that they are not afraid to go for DNA testing. That's why they will go for DNA testing. And now they are coming before this honorable court taking U-turn. That is a factual position. And how can they are twisting and turning the case so opposite, and they are now casting aspersion upon the deputy commissioner, lordship. That is also one very unfortunate thing. And whatever lies they misled this honorable court, if it is turned into truth and DC's decision, he was given a quasi-judicial to take up quasi-judicial decision, because the proceeding took 2 days, and this honorable court gave the power and authority to the deputy commissioner to take a conclusive step in this dispute, Lordship. Now they have said this and that, but in front of the whole parties, they say that they will go for DNA testing. Now they are making a U-turn. However, Lordship, allow me to kindly, they are claiming that they want to go by the whatever has been submitted before this honorable court and whatever has been produced, evidence was produced before this, before the deputy commissioner. Now, my lord, here, some of the factual, even in all human probability, Lordship, the first point is, this petitioner, Lordship, we all know that right after passing the metric examination, before the students go for colleges, scheduled caste, scheduled tribe, and indigenous certificate are procured. And my lord, in your wisdom, knows that we as Nagas by blood, we practice that. We take indigenous certificate, scheduled caste, scheduled tribe certificate, and we all, scheduled caste as a scheduled tribe, we all get metric scholarship, post-metric scholarship till our finality in the degree level, Lordship. Now this, just even in human probability, a grade 4 employees doubters, they pass all the degrees, they pass BA, they pass MA, and in 2018 only they applied for the indigenous certificate. These are also probabilities, but before this honorable court to say as to, had they been Nagas by blood, Simi by blood,
Zimomi,
Lordship.
this is because in 2016, government issued a notification
Lordship.
to replace the all ST certificates by the new format.
Yes. Lordship.
This is the issue. That is why she reapplied again in 2018 so that the all ST certificate can be incorporated in the new format. We should not confuse this.
Lordship, here in my previous writ petition as well as present writ petition, I have impugned that they have, after passing MA degree, only I have, whatever I'm submitting, I have even stated in my previous, but they did not corroborate that. They did not apply. Lordship, here also, in the previous writ petition also I say that they applied only as a semi by blood, by matriculation. Everybody gets scheduled caste, scheduled tribe certificate and they apply for post-metric scholarship. That is how we, the students survive. That was not done even in human probability. That was not done, and only in 2017 in order to apply for this NPSC post, they applied only in 2017, Lordship. After finishing their education, that is one aspect. I will pray before this honorable court to keep even this factual position, factual metrics before this honorable court. Now they are saying that the Eastern Simi Hoho, and my lord, even in all human probability, who Eastern Sim Hohos or student bodies, every year all are getting backward quotas, backward appointments are being done. It is not between the respondent number 6 and the petitioner. Had it been in between them disputing, that is one thing, but this is a dispute even before the issuance or even right after the written examination, before Viva voice was taken. This issue was cropped up, and even legal notice in the previous case also, legal notice was issued by the Eastern Simi Hoho before submitting a complaint before the controller of the examination and whatnot. And that was all done prior to even Viva Voice was conducted, Lordship. And even in all human probability, Lordship, apart from the law, the fact that how can an Eastern Simi Hoho or the Kipiri Toingsang District Students, Simi Students Union deny a bona fide Simi of her legitimacy as Simi bona fide member and employment, Lordship? That is out of question. This is not an issue between the respondent number 6 and respondent petitioner, when they issued legal notice, when they submitted this complaint before the authorities, the respondent number 6 was not even in the issue, that he was not even selected, they were not even selected, but this issue was brought up because it will set precedent, and this is very sensitive issue, Lordship. Lordship, in your wisdom, knows that this is a very sensitive issue, and how can a body, a responsible body like Eastern Simi Hoho and the Students' Union deny a bona fide Simi member an employment of backward quota, Lordship? And apart from general quota, this is a backward quota, and this is very sensitive. And the reason best known, they did not implead the Eastern Simi Hoho or Eastern Simi District Students' Union when they were the complainant, even before the result was out. So, though all those are probabilities, even in human probabilities, Lordship, this can be taken into consideration. That is, they did not implead the organization, and organization can never deny a bona fide sumi of employment. Now also all backward quota is coming out. Did ESU, Eastern Simi Hoho or the student body ever go against any bona fide sumi for backward quota? My Lord will kindly appreciate that number, that also. Then another aspect here, before me going into the aspect, I want to say, my Lord, by same authority, 3 indigenous certificates was cancelled: Lovitoli, Kavitoli, and Levi. Now, all in their school education documents, in their indigenous, in their shuttle tribe certificate, everywhere, 3 of them entered Hotoshe Simi as their father in their educational qualifications from matric till BA, MA. Now, Lordship, by the same order, these 3 were cancelled. Now, before this honorable court, my Lord, they themselves have read out before this honorable court that they are saying that 2 others are Onil Rava's daughter. That's why they are not before this honorable court. But they are still saying that Levi is the daughter of Hotoshi Simi. How can from the same Lordship, if Levi Simi is considered as Simi bona fide, then 2 others, they are now saying that they are claiming before this honorable court in the first place, in the first writ petition, they are saying that they are Hotoshes. When we put the issue before this honorable court that how can 3 were cancelled, how can only 1 petitioner come before this honorable court?
Ms. Zimomi, let us consider the writ petition.
Lordship.
And it's limited to the direction given by the
Yes,
Deputy
Lordship.
Commissioner to
Lordship.
undergo DNA test.
Lordship.
Rest, we are not confined to all this because earlier writ petition has dealt with all this aspect.
Lordship.
Writ petition, earlier this court directed Deputy Commissioner to have an inquiry, then pass an appropriate order. Deputy Commissioner did the inquiry. After the inquiry, or in the process of the inquiry, he decided to have a DNA test.
Lordship.
Now, this is the crux of the whole writ petition, whether petitioner should be permitted to go for DNA test or not. And if this court holds that no, petitioner cannot be allowed to go for DNA test,
yes, Lordship,
if she is not willing.
Lordship.
And Deputy Commissioner then in that matter will have to decide on the basis of evidence that is before him now.
Lordship.
And pass an appropriate order. That's on that context. Now about all these 2 other children having the same name of the father, all those are not.
Lordship, since they are now claiming before this honorable court, what documents are best and presented before the Deputy Commissioner? They have added even the 3rd prayer. I say that after the respondent have already filed affidavit in opposition, how can they change? Or
that 3rd prayer, I've already made my mind clear.
Lordship. So here the issue here is, Lordship, my Lord, in your own in their all paragraph 6, they have already read out that they are not afraid of taking a DNA test. Lordship, that is one aspect. Here, DNA test mostly is an issue between a husband and a wife. My Lord is very clear on that. I need not elaborate further to appraise this honorable court wisdom. It's an issue between a husband. Most of the DNA test is an issue between a husband and disputing husband and a wife. Here is a question of, it's not between a husband and a wife, and the petitioner and their family has whole bundle up together. And Lordship, I will just honestly say that whatever statement is given is all tutored and all Lordship manufactured, because why I'm saying this is, in the first place, this Hotosha Simi said that he has adopted levy, and after coming to know of the notification issued by the government that adopted non-locals cannot be accepted as bona fide Nagas by blood to get employment, then he started this issue of levy becoming his illegitimate daughter. Lordship, these are I will just say up to this extent. Now, there were, my Lord will kindly see that. Now the DC, why the DC? I call up my clients. In the evening, they call me that they wanted to go for DNA test. That was informed to me, because in front of the whole parties, they wanted to go for a DNA test. That's why the DC has decided to go for DNA test. I said, okay, since that is that will be the only option to settle the dispute. Here, between the DNA test between the husband and wife dispute is there, my Lord, for children. Here, my Lord, the dispute is, there is another remote dispute here. Basing upon this, the appointment of the petitioner will arise, Lordship. And how do even in all human probability, how do, without the indigeneity of the petitioner in dispute, in mystery, how will this court or the DC or any other, how will it be decided? That is the issue here. And this is a very sensitive issue, my Lord, pertaining to backward quota appointment, Lordship. It's not general. So, Lordship, this is the issue. They have already, they themselves have stated that even in their own writ petition, they are not afraid to go for DNA test. Now, after going home and sleeping, why they did the U-turn? And it was not only before the DC, it was before the whole party. How many parties were there, Lordship, that my Lord will kindly come to dear annexure D, page 47. Page 49, the last portion. All the statement they have already read out. Lordship, I will not read out since they have already read out. And this is not the petitioner number 6, but especially the ho-hos that are fighting for this outcome, Lordship, whom they are necessary parties, but they did not implicate. They are saying that it was in the previous, but now also the ho-hos were called and ho-hos were party to this second writ petition, second challenge before this honorable court. Why? The preliminary objection is that non-joinder of necessary party is fatal to the writ petition, Lordship. That has to be considered. How can they are the necessary parties, Lordship. Non-joinder of parties, that is another thing. But this is a necessary party. They have a reason in not including the ho-hos. They are scared. They are afraid because they are non-locals. And they know the circumstances. They know the consequences, Lordship. So the 49, the last, can a DC, Lordship, can the respondent, after hearing all the stakeholders involved in the case, the district magistrate decided to conduct DNA test of one Levi Simi, Onil Rava, and 3 Hotosha Simi, to which both parties agreed to comply. Eastern Simi Hoho and KDDSU agreed to bear all the expenses regarding the testing. Then the signature that was procured on that day is 29 members, both the parties, Lordship. They took the signatures. Now, just merely they came before this honorable court. I will say misleading this honorable court that we never agree, and they made U-turn and they made a false affidavit and submitting before this honorable court. We are not afraid of DNA test, but we did not consent. But how can, then in that matter, Lordship, can the district magistrate become a liar? Lordship, all those things are they challenging the DNA test itself speak for itself, that they are not true to themselves, Lordship. Lordship, I wouldn't go into the other outside the factual submission, but I will read out, I will just read out, Lordship. If there is anything, because this involves the whole future of Simi backward tribe quota, and this is a very sensitive issue, and this case largely depends upon the decision of this honorable court, Lordship, and it will affect even the future consequences, as well as it will set precedent both ways, Lordship. From paragraph 2, I will start.
Of your content?
Of my content. I will just go through this, and whatever they have submitted, I will just go through my affidavit in opposition. 2A, that the petitioner, Levi Simi, is the biological daughter of Sri Onil Rava, a non-local, who had permanently settled at Mokokchung even before marrying the petitioner's mother, Srimati Yevili Simi. Sri Onil Rava, while serving as Mali at DC office Mokokchung, met Yevili, the petitioner's biological mother, when she was staying with her biological brother Sri Hotosha Simi, who was serving as peon at Texas office Mokokchung, and later on transferred to Zneboto. Sri Hotosha Simi and Srimati Yevili Simi are children of late Zuhok Awomi from Yangzingtong village under Kipuri district, and biological brothers and sisters and uncle of the petitioner. As per the pay and allowances case dated 31/10/1986, Sri Hotosha Simi was already serving at Texas office Zneboto. My lord will kindly see peruse annexure 1. This is very crucial. He said that Levi was born in 1992 and he had an extramarital affairs while serving at Mokokchung with one Mina. This is a made-up story. One Mina in 1992, Levi was born through Mina. But by 1986, he is already transferred to Zneboto and was serving at Zneboto, Texas office, Lordship. This is the payroll. And all these allegations, they are silent. Whatever we have submitted, placed before this honorable court. So my lord will kindly see page, I have type out 1. Page 23. Hotoshe is at serial number 523. This is the payroll, Lordship. This is month of October 1986 at the top. So that will suffice, my lord. How they're making up all these stories. In 1992, Levi was born while he was serving at Mokokchung, had an extramarital affair with one Mina, a Mokokchung citizen, Nepali citizen. But by 1986, his family is already settled way back at Zinebotology. So that will prove that all those lies are made up. B. That Sri Onil Rava retired from service on 28/2/2003, and as per his pension payment dated 28/10/2004. His date of birth is 1/3/1946, and his wife Srimati Yevili Sumi, date of birth is 13/4/1970. They have 6 children, 1 son and 5 daughters. 1 Mughali, 2 Vinod, 3 Inali, 4 Lovitoli, 5 Kavitoli, and 6 Levi, the petitioner. In the pension payment order dated 28/10/2004 of Sri Onil Rava, the recipient of his pension, Srimati Yevili Simi, Kavitoli, date of birth 13/12/1989, and the petitioner Levi, date of birth is 5/1/1991. Though it was said 1992 in his education qualification. This one I need not show my lord, or the documents. Or if my lord will peruse, they are Onil Ravas is 25, his pension 27 is his pension book, 27. So here Yavili, Kavitoli, Levi, the name of Yavili, his wife, Kavitoli, and Levi, Lordship. C, paragraph C. That Sri Hotosha Simi, the petitioner's uncle, retired on 39/2014 on superannuation of age, as per his pension payment order dated 26/2/15. His date of birth is recorded 2/9/1954, and his wife Srimati Lukhuli H. Sema, date of birth is 1/5/1962. They have 11 children, 5 sons and 6 daughters, Vitoli, Asheto, Helena, Totoli, Awoto, Atoshe, Agali, Anakali, Lina, Avika, and Hinoto. In the pension payment order dated 39/14 of Sri Hotoshe Sema, the recipient of his pension is his wife, Srimati Lukhuli H. Sema, as the children were all overaged. D. That on 21/1/2007, Sri Hotoshe Simi entered a deed of adoption backdated 15 June 1990, declaring that he had adopted Master Onil Rava from his father, Sri Ohorian Giver, who was by then 35 years of age, and Hotoshe adoptive father was only 40 years of age, and swearing that Horian's wife died, leaving him a minor son, Master Onil Rava, and he having become paralyzed. Sri Horian.
Is it necessary to read all this?
Lordship, these are just introductory. Then the fact.
Let's go into the facts.
Oh, let's go. F. I will start at F, Lordship. All those are just that prior to the declaration of the aforesaid result, at the time of written exam declaration, it came to the knowledge of Eastern Simi Hoho, ESH, an apex body of Simis of Kipuri District and Kipuri Toingsang District Simi Students Union that Miss Levy is not an indigenous Simi by blood of Kipuri District and daughter of one Sri Onil Rava and Srimati Yavili Simi. But the petitioner had falsely represented herself as the biological daughter of Sri Hotosha Simi, her mother's brother and uncle in all her educational documents from HLC onward, including her sister Lovitoli, Kavitoli, adopting their uncle Sri Hotosha Simi as their father. Having proof and evidence of the petitioner and Kavitoli, the answering deponent file RTI dated 27/20 and by reply dated 11/8/20, the Nagaland Board of School Education furnished Lovitoli's admit card, and needless to say, their natural parents Onil Rava and Yevili Sumi settled at Mokokchung, and they were born and brought up from Mokokchung. The HSLC examination centers of the petitioners and her sisters were all Mokokchung and not Kipuri or Zineboto, where their fake father, Sri Hotoshasimi, had settled for decades. Lordship, whether my lord will, it's not necessary to peruse the documents.
It's up to you. No, not necessary.
Okay, Lordship. I will just go by the G. It came to light that the petitioner and her sister, impersonating as their uncle's daughter, procured indigenous certificate and scheduled tribe certificate from the Deputy Commissioner Kipuri, respondent number 4, on 9/6/2017, falsely representing as native of Yangzingtong B village under Kipuri district. By virtue of it, the petitioner appeared the aforesaid NPSC exam as Simi, tribe from Kipuri district candidate, and got selected out of 2-person reservation for Kipuri, Simi backward quota, tribe quota. In her scheduled tribe certificate, the petitioner has further given false statement that her temporary resident at Zheangzhongtong, when her father Onil Raba and mother Yabili had permanently settled at Mokokchung before he entered service or got married, and even her fake father, Uncle Led Yangzingtong village, had permanently settled at New Colonies in Heboto. H. That on coming to know of the fraudulent act by letter 2021-10-2019, the KTDSSU lodged a complaint before the Controller of Examination NPSC to nullify the indigenous certificate of Levi Simi and to select bona fide indigenous Simi of Kipuri. However, in spite of it, when the final result of NCS, NPS, NSS, and Allied Service Examination 2018 was declared on 19/12/19, Miss Levi Simi was shown selected under BT quota of Simi tribe. In agitation, the Eastern Simi Hoho also submitted letter dated 27/12/19 to the chairman of NPSC for nullifying the selection of Miss Levi Simi bearing roll number 4568-67, who is a non-local, basing upon the fact of joint verification conducted by Eastern Simi Hoho with Yangzingtong B Village Council, GBs, on 23/12/2019. Here, a little explanation is that, Lordship, the first verification along with the Yangzingtong B Village, Levi is claiming to be her village and Simi Hoho. Everything was okay. They say that Levi is not from our village, but thereafter, slowly, the circumstances changed to present situation. Otherwise, the documents are here. All the documents are here. That I, in person to it by someone, order bearing number so and so, dated 23/1/2020, the Deputy Commissioner Kipuri directed the petitioner to appear before the same with her family with original documents in favor of her claim as BT from Kipuri district. The village council chairman, BCC, and GBs of Yangzingtong B village, president and general secretary of Eastern Simi Hoho and KDDSSU on 29/1/2020. J. That it appeared by letter number so and so dated 6/2/2020. The DC Kipuri submitted report to the government. However, by letter number so and so 17/2/2020, the government requested DC Kipuri to thoroughly re-examine. Lordship, prior to this sitting also, the DC was redirected by the government to sit even second time after submission of the verification report. It has been thoroughly made, and this is the fourth step. The present impugn order is being challenged after fourth sitting. So even after submission, the DC was again directed by the government, requested the DC Kipuri to thoroughly re-examine the case and to submit the report within a week. Accordingly, by letter bearing number so and so dated 18/2/2020, the DC Kipuri communicated to the government that on receipt of the documents submitted by my clients, it needs further examination and also with district administration Mukokchung, and then shall forward to the government at the earliest. This verification was done even by going to Mokokchung, Lordship, the first issue. K. That, however, there was no outcome on the verification process and the answering deponent submitted representation dated so and so to the DCKPRI and the Commissioner and Secretary PNR for resolving the NPAC issue regarding Secretariat Assistant post under BT Kotaki Puri semi expeditiously. In pursuant to it, by letter number so and so dated 25/5/2020, the PNAR department directed DCKPRI to submit verification report of Miss Levy within 1 week. However, even after lapse of 1 month, the DCKPRI failed to submit the final verification report to the government. Annexures, I will not read, Lordship. I will just read out the facts. J. That the Kipiri semi-district backward tribe quota involves whole indigenous semi-population under Kipiri district and not of individual answering deponents. And since 6 months time-bound period for candidates in waiting list to be appointed to any post conducted by NPSC was to expire on 19/6/2020 by the deponent, for the deponent, without any outcome, the loser would be indigenous Simis of Kipiri district in general and having no option. The Eastern Simi who served legal notice dated 17/6/2020 to DC Kipiri to be held responsible in case of forfeiture of backward quota, tribe quota of Simis, a copy of which was submitted to the Commissioner and Secretary PNAR Department and the Chairman NPAC respondent number 2 and 5. That is Annexure 20, Lordship. Legal notice was also served in the year 2020 by the Eastern Simi Hoho and not by the respondent number 6, Lordship. This is why I'm saying that Eastern Simi Hoho and KDTSU are necessary parties, Lordship. And when necessary parties are not included, it is fatal to a writ petition, Lordship. In your wisdom notes, I don't have to explain much. Then, legal notices at page Annexure 20, Lordship. It's my
We'll take up tomorrow.
Lordship.
You come with a concise this thing
Lordship.
on the issue involved in the writ petition.
Lordship.
Not
My
traveling
lord,
here.
my respectful submission, my lord, subject to repetition. Of course, I'm not denying the right of the respondent number 6. My lord, the factual statements which my learned friend is advancing were all part of the first writ petition.
No, that's what I'm saying.
So my respectful submission, it is whether it is necessary or whether this court should allow that to be repeated all over again, because it is part of the subject matter of the first writ petition.
No, that's why this court is telling the council to come with the
Precise
submission with regard to the issue involved in the present.
Exactly,
petition tomorrow.
exactly.
That's what- Doesn't matter. You have made your arguments. I don't think I have any questions to ask you. Your stand with your affidavit,
Yes.
particularly your paragraph 12. Heard Taka Masal, senior counsel, assisted by Mr. Aaron Long, counsel for petitioner. Also heard Mr. Tiba Pomlan, state counsel for the state respondents. And Ms. Z. Zimami, learned counsel for respondent number 6.
Lordship.
Heard in part, post for further hearing. Tomorrow is what date? Oh,
As part heard, Lordship.
on 13th, as part heard.
Lordship.
No, I've said heard in part.
Lordship.
Any more?
Obliged, Lordship. Of course.
Angkai foto kijang